would he have been able to proceed without your signature?
That has happened in the past, as I said.
Now, in this circumstance, would he have been able to proceed, changing 20% to 29% of the IO transaction, taking up the full position, so he could have, and you need not to sign?
Yeah, I didn't have to sign. Quite frankly, I didn't have to sign, but because he was concerned that it's bigger than what he thought we could do.
So he has signing authority over billions as well?
Yes.
On his own?
Yes.
And the fact that it had not gone to the PMC would not have affected his ability to sign?
It would have, but concurring with me that I'll be able to get the PMC ratification at that point.
So just for clarity then, the co-signing was necessary because PMC had not taken place?
Well,
if PMC had occurred, he could have spent without you signing?
He could have.
If the PMC had taken place?
Even if the PMC had not taken place,
he could have signed on his own.
Yes, and I could have given him comfort verbally without signing that we will have a PMC at the next meeting to ratify.
Just go back again. You say you would have given him verbal comfort. You would not have put it in writing.
I wouldn't have put it in writing.
Okay. And so you can verbally say go ahead, and there's no record of that if there was ever a dispute.
Because all the information that requires us to take that decision is there.
Yes, but your verbal communication is adequate as far as you're concerned.
Yes.
Okay. And then in terms of round-robin resolution, how often were you reliant on round-robin resolutions?
I can't give you statistics, but
it was quite common?
We've done many.
Decision by round robin and taking a decision in a meeting?
Well, round robin simply says that we probably are not able to meet in a meeting.
Sure.
But the information that is there is enough to make a decision. Now, in situations where people have issues in a round robin resolution, they will be concerned on this and this and this. That's why, can this be resolved? So they are still able to ask questions depending on whether they have access to technology to do so or not. So round-robin resolution simply facilitates a decision without being in one room. It's always ideal to be in one room, because we can then eyeball each other and talk about things. But in situations where that is not possible, round-robin resolution is still effective.
But that's why I'm asking. It is effective, but it should be used sparingly, in my view, not often, because the difference is when you meet in a room, as I would understand the purpose of a PMC or an investment committee or a board meeting, is to exchange views and ideas so that when you're listening to a person's presentation or argument, you may well change your mind. Resolutions should only be in extraordinary circumstances, but you've indicated that they were frequently used.
Well, not in that way, but in circumstances where it requires so. We've spoken last time we met about the volume of transactions that we go through.
Sure.
So relative to the volume of the transaction, round-robin resolution will be much smaller in percentage terms.
But I accept it's percentage terms, but again percentages can be deceptive, but you indicated that it was a frequently used tool just now. I'm just asking...
Commissioner, let's not use the word frequently. Let's say it's used when it's necessary. I'm uncomfortable with the word frequently.
Can we get a report on how often serious decisions above a certain amount, and this is 4.3 billion, there's a few billion rand at stake in these, are decided by round robin? And I fully accept, it's not always necessary or always possible to get the full team around the table to take a decision. But that is the purpose of having the meeting and the PMC, etc. So, okay, that's... I wanted to just raise the issues around there.
Commissioner, can we add that they also look at IC and other fields? because it's not only PMC that does outreach.
No, that's why I said
It has to
it's
be
all of them.
Yes.
Yes. It should be all of those critical meetings that take decisions, how often that is done around Robin. Thank you.
Thank you, Commissioner Wonju. Do I understand the position correctly that it's normally used where you can't put together the members of a particular committee that's supposed to deal with the matter?
Absolutely. You cannot put together members of the committee. Resolution becomes the easiest way of allowing everyone a chance to sign off on the transaction.
Just a quick follow-up. Just in terms of the timing of the transaction, it was like in December, but have you had this caused so much pressures because the PMCs couldn't meet because people were not there? But have you done these kind of transactions in December?
I cannot recall. Yeah, I cannot recall.
Yeah.
It may be the first one, you know.
Yeah.
Because I guess the evidence leaders can check, but it's, yeah. The very recent one that I can remember is I
Was the one, and it was a big money transaction. You know? Because if the PMC meeting of things could have been different, isn't it?
That's true. That's true.
Yeah.
And the 13th probably,
Yeah.
because we tried to get the 13th as well. And most importantly, we tried to get a round resolution on the 14th to try and regularize the signing. That still couldn't work until we met on the 20th.
So sorry, just one other question in relation to that. You do indicate in paragraph 430 that from time to time you would sign a round-robin resolution before other required signatories had signed it. Would that not have been read as a signal of approval of you?
It requires the signature of everyone.
Sure, but I'm saying if I get something signed off before anyone else has signed from yourself, it signals a different question that you are actually saying, I'm happy with this. I'm not saying it's a negative or positive, I'm just saying the fact that there's a signature when it comes to me already gives me as a member of that committee, whichever one it is, on a round robin, that you have already approved it. That's what we read, yes?
I'm a member
Sure.
of the committee.
Sure.
And my colleagues, the way we've worked all along, sees me as a member and not necessarily the CEO when it comes to this sort of matters. They do question me, they do challenge me, and they are free to do so, they've done so in the past. So I don't see why signing before everyone else is a member becomes a problem.
I don't think it's a problem, but it's just a matter of, let me use the term perception. It's signed already by the CEO.
I think it's misplaced, Commissioner. We've worked with the team for years, and that's what we've done in the past. I've signed resolutions at some stage, and they say, but we're not comfortable with this. And, you know, and again, it's this issue of saying I'm powerful, which I have, is a fundamental problem with it, because it's still there. You can see it in the background coming again and again, you know. I was just performing my job as a CEO of business, leading people.
And we accept that.
And
we accept that.
Yes, except that I'm not powerful, right? Is that what the commissioner said? I'll be happy if you say that.
No, I'm saying I accept what you say, that you're not powerful, etc.
Thank you, Commissioner. Really like it.
Just another question in terms of the follow-up. The pressure to do this transaction in December, and I know they have given some reasons, you know, but was the in sort of in which the at Nazareth had any bearing on doing this transaction in December? This issue was raised somewhere that there was some pressure to there could be change of the factions or leadership in the
Yeah, I heard this, I think it's in the commission, that from where the PIC was sitting, that's not true. I think for us, the very proposition was around the SASO contract, which would then give the real impetus to the project. The ANC conference, we really thought that it's could be part of the risk. Maybe this should have highlighted that there is this conference.
So there was no pressure from you,
From the PIC side.
the PIC, Mr. Mulibati, you from outside forces to complete this transaction?
That's true. The only pressure will be on the timelines that we can do. Nothing other than that. That I'm not aware of.
At last, Mr. Mohammed.
Thank you, Mr. Commissioner. Dr. Matjila, you also say that you signed the irrevocable subscription form on the 14th of December on the strength of recommendations that you received from Ms. Taukubong from ESG, Ms. Abrahams from RISK, and Ms. Sitsedi. And we know that Ms. Abrahams denies that she gave you.
Look, Commissioner, all I can say is that my colleagues were under pressure, and I've seen it in this commission. Some people who testified here, who we were closely with, who had changed completely in their tone and how they talked about me. So I'm not surprised if some of them were not comfortable or uncomfortable saying yes to the call, because once you get associated with argument, you get suspended. People were scared, including Mr. Mulibati, who we communicated via WhatsApp at some stage, and he said to me, look, he's under so much pressure, that he's going to be suspended, he may face a suspension, and his first prize is to protect himself. So it was more about self-preservation more than anything else. So I'm not surprised, but that doesn't change the fact that work was almost completed, and therefore a decision could be taken, including
the appraisal report. If you look at the appraisal report of the 14th, Siani actually lifts up the ESG score of 44. He wouldn't have guessed that there is a 44 score. He would have gotten it somewhere else.
Yeah.
So.
But as far as you're concerned, Dr. Matjila, and you say this in paragraph 431 of your statement at page 154, that you telephoned these people on the 13th of December.
Yeah.
So you, as far as you're concerned, and it's not something you would have lightly forgotten that you've spoken to people and they've given you the recommendation to sign.
Yeah, I mean, I wouldn't be. If they say they deny that I haven't telephoned them, I don't have much to say, except that I recall confirming with them that the reports are almost ready, and that's what I was told.
Yeah. So the point I'm establishing is that you spoke to them and you wouldn't be mistaken as to whether or not you have spoken to them.
Look, I'm not sure. I mean, if they say I haven't spoken to them, it's quite difficult for me to say. Maybe I didn't speak to them, or maybe I spoke to them. I can't remember. It was for me. It was such a straightforward matter that, I never thought that it will raise an issue that no, I wasn't called.
Yeah.
But I can only, conclude that it's got to do with the pressure that was at the PIC.
So the basis of calling these particular people, Ms. Taukubong, ESG, Ms. Abrams, RISK, and Ms. Sitsedi, Legal, what was the basis of calling these particular people? Because they weren't directly involved with these are different people from those that are mentioned by Mr. Siani as people who were directly involved with the...
Yeah. I normally deal with the executive heads or acting executive heads to confirm certain matters because they are in charge of those areas. So I wouldn't call a junior staff member, necessarily, unless really it's on some other matter that requires me to talk to them, directly. But I normally check with the senior person responsible for that area.
So, in relation to Ms. Setsedi, Dr. Matjila, what was the basis? She wasn't acting legal executive head until the 15th of December. So on what basis would you have spoken to her on the 13th? If that, what you're saying, is that you communicate to executive heads, on what basis then would you be speaking to her?
I'm not sure, but I thought she was acting at that time.
No, that's incorrect.
Okay, no. Well, she's very senior in legal as well. She's acted several times. Maybe I wasn't aware that she wasn't acting at that point.
Might I, with the permission of the commission, hand up, and Dr. Matjila will confirm that there's a circular by email that's usually done when people are acting, correct?
Yeah.
Are you suggesting that the people whom he phoned were not heads of those departments? Is that what you're suggesting? You, Mr. Mahab.
Mr. Commissioner, my question to Dr. Matjila was, on what basis did he speak on the 13th with the people he mentions in paragraph 431? And he says, no, he doesn't speak to junior staff, he speaks to executive heads. Now, my question is, Ms. Setsedi wasn't executive head until 2 days after the 13th. So it can't be correct that she had been executive head, and she wasn't either working directly on the due diligence. We know that Ms. Sasa Faku was working on the due diligence.
But he doesn't, if I understood last time, he doesn't deny that he spoke to certain people, let's say the ones that you mentioned, on telephone or over the telephone, does he? Dr. Matjila, you don't deny that you did speak to them?
Yeah, I recall speaking to these people, Commissioner. My colleagues, these colleagues of mine. Just
spoke to them in respect of IO?
Yes, just to check how far they are with the, as I said, with the different reports.
Yes.
Yeah. Okay. So if Ms. Setsedi was not acting at that point, then it's a mistake. I shouldn't have called her. It would have been probably Mr. Nessan who was in charge at that time.
So it may be someone else.
Ms. Setsedi is very senior. She's acted on a number of occasions. So it could have been a mistake. Thanks.
My point is a simple one, Dr. Matjila, and that is the answer you gave in relation to why you spoke to those specific people. And this is also on the back of the question. You wouldn't easily forget who you spoke to, firstly, but also Ms. Setsedi hadn't been involved in this deal. So he, as far as this deal is concerned, only started acting on the 15th of December and only then started really getting to grips with what had been going on in the deal. So on what basis would she?
Yeah. Commissioner, it's very important. I mustn't be treated as a superhuman being here, that I can't forget things, I think that's incorrect. I am a human being, I also forget. I remember calling these people. If they say I made a mistake, then I will accept that it's a mistake, but I'll call someone to check if all these reports are ready. That's all I can say about this, Commissioner.
So in respect of Setsedi, you might as well have made a mistake there.
Yes, but
if she wasn't is it a he or she?
If it's a she,
it's a she.
If she wasn't the person, if she says she was not the person that you called, then you would be making a mistake.
Yes.
Yes.
Yeah.
Thank you, Mr. Commissioner. Now, can we then move on to the question of signing the irrevocable subscription form? You're quite well versed with the implications of signing a irrevocable subscription. In paragraphs 458 to 459 of your statement, you in fact also explain the rationale for it being irrevocable. Correct?
Yes.
And so you were well aware of the legal implications of, as CEO, signing the irrevocable subscription form.
Commissioner, I think the form is very clear. You know, it's irrevocable. If you read it, it says that I, whoever, irrevocably undertake to perform certain things. So it's legal. It's doing the transaction, and I'm well aware of that. So is Mr. Mulebati and all the other members of the team that are involved in IPOs.
Yeah.
The whole team understands that IPOs, once you sign that form, then is irrevocable.
Yes. So, but to the outside world, once they see and you've signed a CEO. And really it's the CEO's signature that matters most, because to the JSC, to AO, that is the signature that matters most.
Yes, because I'm an authorized signatory, but it doesn't mean that there are no other authorized signatories, including Mr. Mulebati, who was acting as the executive head of listed investments with full authority to sign on behalf of the organization on matters that are within that delegated authority.
Yes. So, and we'll come back to the DOA, the delegation of authority, but you, I take it as CEO of a 2 trillion asset manager would appreciate that the CEO and executive management doesn't have authority save for what it's given by the delegation of authority. Is that correct?
That's correct.
So you don't have any authority beyond what the delegation of authority gives you?
Yes. As far as I understand the delegated of authority to me.
Yeah. So one must, in your position as CEO, confine yourself to the limits of the delegation of authority, and when doing whatever you have to do in discharging your duties, do so with duty of care, and it's a fiduciary responsibility, correct?
That's correct.
When you sign the irrevocable subscription, though, as you've also reiterated this morning, you weren't exercising authority which you say you enjoy, and you mentioned 8.1.2.
That's correct.
You had been exercising authority as you normally would do, where you require PMC approval.
That's correct.
So I just want us to get this clear, the distinction between exercising authority to approve because you have been given the authority to do so by the delegation of authority, which is mutually exclusive from approving approving with the hope or with the intention to get it ratified by PMC.
It's not about hope, really.
What is it about?
It's about being ratified by the PMC.
So would you be sure that it would be ratified?
Yes, yes.
Okay. Were there any other deals where approval or IPOs?
Yeah, just to talk about a point, about the calls which were made to the 3 departments and all that. I just wanted to check something because it's quite important that those 3 people say they were not called. Dr. Matjila said he called them. Are there call logs in the PIC? Is there a way in which maybe Dr. Matjila can prove and say these are the calls I've made and the matter get closed. Were you phoning them from your cell phone or from the work phone?
I don't remember. It could have been the work phone. I can't remember what I used. But most of the time, I would use work phone. I'm not sure if the calls are, there's a call log.
Yeah.
The one thing I know is that the calls that are recorded are from outside, especially in the dealing room. That's where you record calls, but normal conversations within the organization, I don't think those are recorded necessarily.
Yes, but the call logs could show that at least there was this call made to this number without the voice and all that.
Most probably you'll get many of those, and they won't necessarily lead you to say we're discussing IO.
Yeah.
You know, I'm sure my PA will have put me through as well. So there is I'm sure, I think we can check, they can check that. They can check that.
Yes, Advocate, I'm happy. Maybe there are call logs and it could show he called them and then at least that issue is dealt with. Were you coming
We can do that, Commissioner, but I think the point I was simply making in relation to Ms. Tsedi was Dr. Matjila's answer was the reason he spoke to her was she had been acting executive head. And through that circular, she hadn't been, through proof of that circular, she hadn't been until the 15th. So that's all I was trying to demonstrate.
You know, and that could be a mistake that, maybe he thought she was in an acting capacity, but I think one of the key things is just to see, we got two groups saying they didn't get the call. He said he called them, and it's quite critical because that actually made him to proceed with that transaction, So if there are call logs, they would help us in clearing this issue, besides the Winnie Setsedi issue. Yeah? Is that clear?
It's clear. Thank you. Thank you, Commissioner.
Okay.
Commissioner, as I said before, Winnie Setsedi is very senior. She has acted several times and she was familiar with the matter. Maybe that's why I called her instead, unaware that she is not acting, but she's very senior and familiar with the matter.
But could you call someone below the head of the department?
Yeah, very senior
and would
people.
you get the answer that you wanted?
Yeah, very senior people that would be leading a certain transaction, like Ms. Taukubon, for example, she's heading up the ESG listed, but there's someone above her. That will be executive head, Rubina Solomons. So sometimes we do chat to very senior people. Mr. Mulibati is a GM. He's got a senior person above him, that's executive head of listed. But we talk a lot directly with him on various matters because he's, I would say, an expert in the subject matter. So it happens quite a lot. But below, it's very rare that I would ask for opinion on a matter, without going through someone senior first.
And Ms. Abrams?
Ms. Abrams was acting, I think she's head of enterprise-wide risk management in the organization, very senior as well, and she's done quite a few presentation to the PMCs and IC on credit risk matters or risk reports. Very senior as well.
Was it necessary for you to contact them, by the way, or could you have signed without speaking to them?
No. What was very important to know if the reports have got any negative findings that may stop the transaction. That was the basis of the conversation, because then it gives one confidence that the transaction would be ratified under those circumstances. It was very important for me to check that there is no negative findings that may stop the transaction from proceeding.
Thank you, Mr. Commissioner. Now, Dr. Matjila, I find your answer about ratification interesting, that you were sure that you would obtain PMC ratification. And this is why ratification by implication means acting without authority and seeking the person who's got proper authority to endorse what you've done without authority. So for you to answer that you were sure of ratification is interesting. Would you like to comment on that?
The reliance on any decision to do an investment is placed on the valuation, which is the due diligence on valuation, ESG. If there are any negative findings on ESG, we know that one would be concerned about, a legal report as well as risk report. Those reports, once there are no issues and they are supported by those departments, then the transaction goes through. Those are the experts that will advise the committee on whether to proceed or not to proceed. And once they all agree, then the transaction it's a done.
Yeah. So are you saying that you are assured of ratification because of this recommendation that...
Yes.
So are you saying that PMC wouldn't deliberate the reports and appraisals as they are presented? I thought PMC is a deliberative body, it's a decision-making body. It doesn't rubber stamp.
Yeah.
It would have to consider still the merits of the deal.
The critical issue here is it's an IPO that we're dealing with. It's an initial public offering, which is controlled by the regulator, the JSC, by means of a PLS. All the information, as we explained before, we're at pains to explain what the PLS is about and what the IPO is about. So all that information is contained there. Unlike other investments where we have to search for information from all over and verify it ourselves, then it's a different matter, because there we have to debate. There is no authority that says all the aspects have been covered, you can go ahead and do a transaction on that basis. That is the PLS, So there is a difference. IPO, PLS, fairly straightforward because there is a regulator and there are technical aspects that approve on the quality of the information that's going to be used. Versus when we do our own due diligence, then we have to get deep into understanding and probe into matters until we are all satisfied that all issues have been covered. And that takes place, through the different teams, and then they will then present their proposal to us. The same way as an IPO, but we will then probe one or two things, for explanations and clarity.
Yeah, except of course in this case, the PIC had been using draft PLS pre-listing statements.
I accept that. So there's been...
And inherent in that is that it's possible it will change and there could be further iterations of that document.
So it becomes
sorry to interrupt on
academic.
That. Sorry to interrupt on that. But just in relation to that, Dr. Matjila, just now you said that you actually did your own due diligence. So you said just now that you did your own due diligence as well. You didn't just rely on the PLS, you did your own due diligence earlier this morning?
No.
Yes.
No.
You did, you said so.
I said due diligence on the PLS. I never said we did due diligence outside of the PLS.
Well, you just said you did due diligence, but if you meant that you did a due diligence on the PLS, then I would like to come back to that when Advocate Mahape is finished.
That's fine.
Okay.
Thank you, Commissioner.
On this matter, though, before we move off this matter.
Oh, thank you, Commissioner. But of course, the other problem with having already signed the irrevocable subscription, Dr. Matjila, and you will have to accept that you've already then bound the PIC. So whatever processes would be in futility after that, once you've signed the irrevocable subscription. Do you accept that?
Yeah, that's what it is. I mean, irrevocable is a commitment that you will invest.
Yes, so put option, for instance, wouldn't really...
I think I was again at pain to explain what an IPO, the difference between an IPO and a normal transaction where, you know, you are investing alone and therefore you can call all kinds of conditions, you know. IPO, you don't do that because the PLS is standard that it must be applied by everyone else, you know, as it is. If you don't want to invest or you don't like what you see in the PLS, you simply don't invest because you are not able to put conditions. But you can put conditions post or even undertaking post the investment.
Another point on ratification is
Can I talk a bit about the PLS and the forecast today? Just the forecast in terms of the numbers, the revenues and the profits. I mean, like some companies actually don't accept those numbers willy-nilly on the PLS, and they actually do their own, you know, forecast and say this company will do that. And why did the PIC just accept these numbers from GT, from Grant Thornton and all? And just say this is the revenue figures, these are the profits, we'll just put a PE number and come with the value.
Sorry, before we reply, Dr. Matjila, can I add to your question? Because you then said you did a due diligence on the PLS. But before we come to this, I want to just go back, first of all, to Ms. Abrams, and then come back to this, if that's okay. Because Ms. Abrams, in her testimony, said, at the time of the sign-off of the risk report, on about the 15th of December, I was not privy to nor aware of the following, which has since come to light. One, that the irrevocable undertaking or subscription agreement had been signed prior to the meeting of the 20th of December, and two, that the disbursement member was also signed prior to the meeting of the 20th of December. So the question that you consulted with Ms. Abrams, if there had been something else, she was clearly saying to us that she was not aware of where things were at. To come back to this question of the due diligence on the PLS, in addition to my colleague's question there, is having heard the testimony in this commission where the actual value was manipulated from 2.3 billion up to the 15 to 20 billion that Dr. Survey wanted and ended up at 13 billion. The question that you say it's an IPO, but you took all the offering. That was all, the 29% was the entire offering that was on the table, and you paid the price as set out in this manipulated outcome of pricing. That the question was in terms of a movement from if you had done a due diligence on the PLS, did you look at the question of the ownership of the BT 30%, and that it had a valuation of 1 billion attached to it, and yet already back in August there was a letter from BT that this was not part of the transaction, that there was no agreement on it. Did your due diligence on the PLS uncover any of the issues that have been raised in this commission by the people involved, Mr. Malik Sali, Mr. Hardy, Mr. Nodwela, about the manipulation of the information in terms of setting out the PLS, and that the PLS in fact was grossly misleading?
Yeah.
What, in terms of having heard all of that, and that you did a due diligence on the PLS, what did you find, or did you concur? And it relates back to the pricing. Also, sorry if I could, it was then said that the shares were oversubscribed, but none of the other participants in the subscription got any shares, and they were all related party entities. in your due diligence of the PLS and your interactions with Secondjalo over the matter, did you look at who the related parties were and whether that was in fact, why did the PIC take all 29% of the shareholding when there were another R1 billion rands worth for related parties that simply didn't get any shares? What were you aware of? And these are the critical issues, if you did a due diligence on the PLS, that has shown to be grossly misleading.
Okay. Commissioner, hindsight is perfect sight.
No, due diligence was on the PLS at the time.
Yes, how would you uncover that the numbers have been manipulated in the PLS? How is it possible? It's only until when people came here, people who actually worked on the same PLS that they gave us, who never even raised these issues with my team. By the way, I don't do the due diligence. I have a team that does due diligence and they advise me on their findings and make recommendations to me. So it will be very difficult for me, or for my team for that matter, to pick up all of these things if people are conniving in creating this nice looking PLS and say, here we go, Grant Thornton is signed on all of this and so on and so forth. We are happy with the numbers. The valuation is 14.8 billion. When those people who came to this commission didn't tell my team before that there are issues, we are picking up this, we are being pressurized and so on and so forth, we could have acted differently. We could have definitely acted differently. These people who came to this commission from IO and AEI, corporate finance, are the ones who worked on this PLS that was given to the PIC to make an investment based on. So to expect us to sniff all of these things in the PLS, that numbers have been stretched, etc., etc., it's a huge ask. Perhaps that question should be directed to my team to understand how they arrived at the 43 that they recommended to the committee, for us, to the PIC, to subscribe. I'm just a CEO, I'm taking advice from technical experts that says this transaction is worthy of pursuing because the price is right and it's got prospects and so on. It's in their reports. That's what they told me.
Yeah.
But again, they wouldn't have known if they were not told that numbers have been manipulated.
Yeah, just to follow up, some companies actually look at the PLS, isn't it? And they shave off maybe 20%, 25% of the earnings and say, this is what we think is the picture, because they normally think that, the PLSs have got a lot of cream, attached to it. So what do you think of that? And second question is that, has the PIC changed their forecasts in previous, IPOs when they look at, say, the Vodacom listing in East Africa? Have you previously looked at PLSs and change the forecast and say, we don't think this is a good forecast and all that?
Commissioner, it's the right question to direct towards the team that advises. I can't do all of that. I'm merely a CEO. I was merely a CEO. And I believe in my team. I trust them because you can see in what we've delivered in terms of returns. You can see how we outperformed the JSE. This is the same team that put together all of this thing, 4-factor model and all that have you. They do all of that. They do sensitivity analysis, they do, and arrive at a figure that they're comfortable with. So I wouldn't say, I wouldn't believe if someone said to me they didn't do the sensitivity analysis, they haven't checked the base case, the worst case, and the median case. They do all of that. And IO wouldn't be an exception. They did it in Sagamata and said, but this price is 7 rand versus whatever number, because they did do the analysis, intense analysis, So I trust them. Once they say we can do something, I have no doubt because we've done quite well because of their advices.
Okay, so you aren't aware that maybe forecasts have been changed before in previous, IPOs and all that? Are you aware?
You mean aware? You mean prices change in what way, Commissioner?
Forecasts, the forecasts in PLSs,
Yes.
the 2-year, 3-year forecasts. Some companies actually look at them and say there's a blue sky, amount there, and they actually shave them by 25%. Are you aware if the PIC has done that before, looking at the PLS and say we're not happy with this forecast and we are going to change our staff internally?
I think, knowing my team, they would have done sensitivity analysis before arriving at a decision. They would have done a sensitivity on any IPO or whatever, they would do it.
Okay, all right, yeah.
Sorry, just to follow up on a couple of things. If one looked at the question of independent media, which we've discussed previously, Sagarmatha and IO, the pricing has been based on what will be, a hypothetical, if this happens, that happens. Everything has been determined by what may happen, and you determine a price in that regard for all 3 items. Obviously, independent media has not worked out. IO equally has been shown to be very questionable. Sagarmatha, you had, as far as I understand the deal, with not accepting the side deal, but had agreed, barring the question of the JSE withdrawing it, that you would pay 39 Rand plus per share. On all of them, they were based on...
Commissioner, that's not true. I'm not going to accept that.
What was not
We
true?
have not done to Sagarmatha.
No, I know you didn't do Sagarmatha.
Because the price was too high. My colleague said the price is 7 Rand 6 cents. PIC price was 7 Rand 6 cents, not 39 Rands.
So you based your Sagarmatha decision not to proceed on the basis that the price was too high, not because the JSE pulled the deal?
Absolutely.
Right? And the letter that reflects your discussions with Dr. Survey about coming closer to the 8 Rand that would give you a side deal, you say that you were not part of that?
That was the proposal that he sent to us and was rejected because it didn't work.
Can we get the letter copy of the rejection? Because all we have in our file is the discussion where you're passing on this information as part and parcel of what should be considered. So it would be very good to get a rejection letter to say, Dr. Survey, we have seen this, we are not proceeding with it.
Commissioner, there wouldn't be a rejection letter because the transaction was not done.
Where was it decided not to be done? Which committee?
The IC pushed it back to PMC.
Yes.
They said it's within the delegated authority of the PMC, and we said because the price, we are not getting the price of 7 Rand 6 cents, we can't proceed.
Okay, I would just like to see a record of that because that's different from the information. I'm not saying it's right or wrong, I'm just saying it's different from the information that we have, which is the letter from yourself to your team talking about an 8 Rand offer by survey, not a rejection of it.
It was an email, by the way,
It was an email.
Yeah.
Correct. So that's what we have, and therefore if that was settled in the manner of saying we're not going ahead with that, that would be very useful for us to see. So if you have a copy of that as saying we're not proceeding on that basis, that would be very helpful. Because otherwise we only have part of that information.
Commissioner, this matter has been brought to my attention here. I think it's the IC meeting of, that will be DD, how do we do this? DD 58.
Okay.
DD 58, IC meeting of the 23rd of May 2018, where the IC expressly says they don't approve the transaction to participate in the listing, as the price is way above the intrinsic value of 7 Rand 6 cents. It was us reporting back to IC.
But was that before or after the JSC had
We declined it before the JSE. It must have been around the same time, if I recall.
So
Must have been around the same time that the JSC withdrew, but we had already taken a decision that we are not proceeding.
Is that DD 58.2? DD 58.2 or 58?
Yes. Yeah.
Because that's dated 25th of January 2018.
No, it's the one that's dated the 23rd of May, 2018. It's the very last page before part 3 begins.
I can't see, 23rd of May. What's the date?
23rd of May,
2018.
2018.
Okay. 23rd of May 2018. But all of this discussion and Sagamata was being done earlier.
Yes.
Okay. And when did the JSE pull the, say you couldn't proceed? Do you have that date? Just so that we clarify the dates and sequence.
My learned friend, Mr. Munahela, who works on the deal, says it was April 2018.
Can we just get clarity on that? Because if this is 23rd of May and the JSE pulled it on the in April, then there's just a sequencing question there of the timing of this. And this, the record, the minutes actually say, furthermore, the listing was withdrawn by the JSE, so this has to be post the JSE listing.
No, the PIC declining the transaction was probably around the same time, but we had already taken a decision not to invest when we heard that the JSE has pulled the plug.
Okay, I'm just going by the minutes that you referred to, because that is 23rd of May, and that indicates that the listing was withdrawn by the JSE as part of the information in that decision.
Yeah, we'll get the listing as well as the minutes, because this was a report to the IC. These are minutes of the IC meeting that happened earlier. We'll check the dates, Commissioner,
Yeah,
to
no,
confirm.
I'm accepting what you're saying. I just think that it would be very helpful for our records to show the sequencing of that decision-making around Sagamata. Coming back to the question, if I could, on IO, I know if Mr. Sal, and the point that you're making about not knowing when people are misleading you in this regard, perhaps emphasizes the question of a due diligence and the requirements for thorough due diligence and meetings of committees to deal with it. But Mr. Sali said in his evidence that at this meeting with Mr. Survey and Mr. Abdullah, and in our presence, Dr. Survey phoned Dr. Matjila, and among other things told Dr. Matjila that he would discuss the draft PLS that had been prepared for IO with him. That was the first thing. And then the second question is that, were you aware, notwithstanding the other participants, that Mr. Salih said that with the closing off on the 15th of December, he stated, by that point I had not engaged on any other investors other than the PIC and union members around the IO listing. This is 2 days before the closing off. So PIC was taking up the whole amount, and were you aware of that?
No, I wasn't aware.
So the 29%, you were not aware that the 29% was the full offer?
The 29% was the full offer, that which we normally do. I mean, if we want to subscribe for the full offer, we'll allocate the full offer, or we'll subscribe for the full offer, and whoever does the allocation will decide how much they allocate to us. So we were always intent on taking a bigger size of the transaction. That has always been our intention.
So,
Now to be allocated full amount, we were okay with that, because under normal circumstances, you'll get oversubscription and not necessarily get allocated what you want. It may have been less. But doing less would have put the PIC at a position of
Sure.
disadvantage.
sure. But again, the pricing that my colleague has raised around the hypothetical, if this happens, that happens, that happens, and then the pricing determined at that level, as I understood from Ms. Mora as well as yourself, you did not interrogate that pricing. That to you was bona fide, even though it was hypothetical.
Commissioner, again, we have experts that does the work. They are employed to advise us. These are CFA charter holders, these are chartered investment analysts, professionals in their own right, that advise us, because we can't do analysis and also run a big operation like the PIC. It will be impossible.
I understand that, but if you take the example on the pricing, that the growth in income projected for shareholders would grow by 7,985% or 81 times higher, did that not ring a bell in signing off on the investment?
Commissioner, I'm advised by my colleagues that this transaction can be done. We've said it on a number of occasions that they said they recommend an investment, because they would have done all the work.
But what I'm asking is that in your discussions around it, and you get numbers like that, you're a numbers man. If you look at it and say the profits in 2019 would be 36 times higher than in 2017, 3,628% growth. In reality, the profit was 195 million for 2018, which was an actual loss of 31 million, because the entire profit emanated from the interest earned on the IO fund raised by the PIC. That's the outcome.
But the key transaction that has not been concluded here is the BT and moving the BT customer base onto the platform.
But that was never part of it. That in August already was something that IO knew was not on the table. There was a letter from BT saying this is not part of the transaction and that you're misleading, and even on the PLS they said it was misleading. A letter from BT saying this is not part of the transaction. Were you not aware of that?
My colleague would have advised me to do that. I can't remember that.
Can I just ask then, because obviously having heard all the testimony, but in your 229-page document before us, right, you haven't referred at all, especially in this part of the IO transaction, to the fact that you were not aware of any of these things, and we have listened to your presentation on IO as it was, without any question from you in your testimony about saying, with the things that have come to light, how do you feel about that now? That doesn't reflect in your statement at all.
But it doesn't mean we can't discuss it. Because
No, that's what we're trying to do now.
This statement was worked on for a long time. You've seen almost, 40 witnesses?
70-something,
So
but
it was very
Malik
important
Sali
for
was
me.
in May. Malik Sali
It was
came
very
in
important
May.
for me to make sure that I put things that I believe I should tell the Commission. And those things that will be raised in the Commission that I'm not able to cover in my statement, I can always deal with them here. I've been here.
I accept that.
This is the 12th time I'm sitting here in front of the Commission, assisting the Commission in doing its work.
I
I'm
appreciate
being
that.
helpful. I'm not like hiding anything. That Malik Sali and other statements, I'm not responding to them doesn't mean that I'm not prepared to respond to them. I'm here to respond to them.
I accept that. All I'm saying is that it's interesting to me that there was no reference to that at all, but I take it, and I mean, Malik Sali and the others were in May. We are now in August.
You know, and really it's a reason. I thought, let me put whatever I can put in my statement, And I'm happy to deal with things that came up around May or so in this commission.
Just to talk about some of the figures, and I know you might say the team is working on it and all that, but just to put it on the record, I mean the IO figures, the 2017 revenue figures were 478 million, and then there was a forecast 2018 to 4.4 billion rands. That is like 10 times the amount. Then the forecast for 2019 was 7.7 billion rands. I mean, from 478 million, 4.4 billion for 2018, 7.7 billion for 2019. In terms of the profits, 13 million for 2017 for IO, 750 million for 2018, and then 1 billion rands. I mean, this kind of figures surely should have rung some bells, that you can't have a 10 times growth in revenues where you're still going to negotiate transactions. You haven't done due diligences on the transactions. Surely, sort of professionals should have seen that there was a lot of blue sky in these numbers.
My professionals were happy. They said that this can be done. That's what I was advised. It's in their documents, it's in their memos. They say this can be done.
10 times?
Yes, that's what they told me, that it can be done.
Yeah, that's
and I have no reason, and I have no reason to doubt them, because they've done a sterling job at the PIC.
I've been in this industry for a long time. I've never seen such blue sky being accepted. I mean, 3 times. Yeah, I mean 10 times. Transactions haven't even been bedded down, and they just accept it. You're professionals. They just accept it.
Yeah. That's what I was advised, Commissioner.
All right. Okay, thank you.
Thank you, Commissioner. Dr. Matjila, just going back to the question of ratification and its common cause, you've accepted that the idea of seeking ratification from PMC was yours, correct?
Yes.
I just want to go back to the evidence of Mr. Siani, and because this is a permeating theme throughout, Mr. Siani, Mr. Malebatsi, Ms. Khaniwe Adams, and Mr. Vaji's evidence that you assured the team, and this is something that also helped progression in the deal, that ratification would be sought subsequently. So I just want to go through some of this evidence. In paragraph 62 of Mr. Victor Siani's evidence, he says the following: before 8:30 on the morning of 14th December 2017, Dr. Dan told myself and Lebogang Malebatsi that PIC would subscribe for 4.3 billion worth of AO shares in AO's IPO. This timing is based on evidence from a text message. Then he says the following: to effect this, Dr. Dan signed the AO irrevocable subscription agreement and instructed Lebogang Malebatsi to co-sign it, as Lebogang was the acting executive head of listed investments at the time, in Fidelis Madavo's absence. Then he also says the subscription agreement was signed before 11:44, as Dr. Dan's personal assistant scanned and sent it to me at 11:44 on 14 December 2017. Then he says the following: I thought signing the subscription agreement was highly irregular because I had never seen it happen before, and PMC had not yet approved the AO transaction. Then he goes on in paragraph 63, and this is the last part I'm reading. We raised our qualms and these are the qualms he mentions in brackets: due diligence incomplete, lack of PMC approval. These are the qualms they raised, and he goes on to say about entering into the AO transaction, but Dr. Dan overruled us. In an informal meeting I attended around the day of signing the subscription agreement, Dr. Dan said, and he says he's paraphrasing, "I will use my authority as CEO to sign the AO subscription agreement and have the decision ratified at the next PMC meeting." So that's Mr. Siani's evidence. Then just moving on to Mr. Malebazi's evidence on the same question of ratification. He says in paragraph 35 of his statement, Dr. Dan Matjila had discussed with me on the 13th of December, where in paragraph 35.1, Dr. Dan stated that the IPO date cannot be moved. Okay, then in the last sentence of that paragraph, he says he instructed that the team keep to the original transaction timelines. In the following subparagraph, Dr. Dan informed me that he had a discussion with the executive heads of legal, risk, and ESG team. He stated that none of the executive heads are expecting the due diligence reports from their departments to come with adverse recommendations given the work that was done up to that point. Then, in relevant part, the next subparagraph, Dr. Dan informed me that due to the closing date of the private placement being on the 15th of December, he is instructing that the subscription form be signed. In other words, he asked me to sign as executive head listed, in brackets he says PP for Fidelis, and he will sign as the approver of the transaction. This would have been said to me sometime on the afternoon of 13 December 2017. Dr. Dan stated that PMC will be asked to ratify the transaction at the next sitting of the committee. Dr. Dan explained that as CEO and chairman of PMC, he confirms that a ratification can be done, implying that it would not be a breach of PIC policy. So just skipping in paragraph 36.3 says the discussion with the CEO, and this is, he's talking about why he felt he could PP and sign for the AO subscription form. The discussion with the CEO provided reassurance, firstly, that as chairman of PMC and CEO of the firm, he can provide guidance on what needed to be done to meet the IPO deadline. He seemed very confident that there is nothing untoward in the signing of the subscription form if we were to take it to PMC for ratification. Then in the subsequent paragraph, it was clear in my mind that I could not sign the form in my capacity as general manager, given the level of responsibility of that role. However, I was unsure whether the executive head could do so. Even though there was a DOA in place, I felt it important and a duty of care to get input from Fidelis on this matter, given his experience at the PIC. In that discussion, Fidelis explained that the CEO is, and in quote, a higher power than him, and that he would not go against what the CEO had instructed. I had no knowledge then, nor do I have it now, of a policy that contradicted what the CEO said. That is, that transactions cannot be entered into by the CEO and ratified by PMC. Although I was aware that ratification was not the normal way that other IPO transactions were done. And then I won't read it into the record, but in paragraphs 36.6, 36.7, 36.8, that same theme of ratification is clear. And also Ms. Khaniwe Adams as well in paragraph 9 of her statement says, he mentioned that, and she's talking here about Victor Siani. He mentioned that the former CEO of the PIC, Dr. Dan Matjila, had said that payment for PIC's participation in the IPO should be effected, and the process would be ratified at the next PMC meeting. So that is just to demonstrate that ratification was an idea that came from you, and that it was a panacea, it was a cure of what they perceived to be erroneous or something outside process, and they were given assurance that ratification would be sought, and they then derived comfort and assisted in getting the deal done. Is that correct?
Sorry, before you respond, Dr. Matjila, I think there's just one sentence that would be useful from the paragraphs you're quoting, which is paragraph 36, which is again Mr. Mulabatsi, and he says, "But I had no basis to doubt his integrity, and I did not want to be accused of insubordination towards the CEO." So it's a question then of saying, were you being told what you thought would actually be, not give consequence to Mr. Mulabatsi?
Yeah.
I hope you're not confused.
I'm confused because it looks like we're rereading statements from different witnesses that were done a long time ago. But anyway, Commissioner, I think we were at length in explaining, we went to length explaining, the issue of ratification and the basis of doing it. The team was comfortable. Victor Siani, if you look at the investment proposals or the appraisals, whether you're looking at the 13th or the 14th that was done subsequently, they are recommending a transaction, and I don't know who forced them to make these recommendations. They even mention that ESG score, as I said, it's 44, it's a laggard, which is a problem, but that will be solved later on, Mr. Mulabatsi himself says that, confirms, I think it's paragraph 36.2 that you've just read, that he confirmed with Risk Legal that the reports were not ready, not signed, but did not have any material findings that could stop the transaction. He confirms that, and so did Mr. Siani as well. So Mr. Mulabatsi was the acting executive head of listed investments with full authority to sign in terms of the delegation of authority. The fact that he said he wasn't unsure, it's another matter. Probably he felt that way. Now that he was in front of the commission, he was coming to the commission, but at the time when we were doing the transaction, he didn't show that concern. He didn't come across as somebody that's worried. His only worry, you must remember that he had already signed one form, already completed, that he showed me, signing for 19 million. So I said to him, well, increase, because what you're signing is so small that we're going to have a problem. This is an investment holding company. This money is going to be spent, and we have to have a say in how it's spent in building the portfolio. And there's an impression, by the way, in the market out there that PIC has lost money. I don't believe PIC has lost money, because the last statement that I saw showed me that the 4.3 billion is still there and earning interest. We just need to deal with it somehow. I have recommendations on how to deal with that. But the fact that I want to drive home or stress here, Commissioner, is that I just didn't understand the behavior of my former colleagues. It shocked me actually when they appeared before the commission, saying what they said, that they were being forced to do things, etc., etc., when they had written memos on this transaction telling us that they are in support, it can be done. Mr. Mulabatsi coming to me with a signed form of 19 million, and I said to him, no, let's subscribe for more because this is small. That's when he said, but 29 is a little bit too much. I said, but that's strategic position that we need to take if we have to in order to control this. And he signed, and I co-signed with him on the basis that the meeting will ratify, and I've explained that the meeting would ratify on the basis that the key reports are not negative about the transaction. These are reports from experts, you know, who once they have recommended the transaction, it will go through. We have attempted to do round-robin resolutions without fail. I mean, with fail, of course. We didn't succeed in doing those round-robin resolutions to regularize this. But I was confident on the basis of the information that I have that we could subscribe and ratify at the next meeting where we are able to form a quorum. You know, so ratification is not an idea. We do have a number of ratifications that we've done, post-transactions. We've done Sibanye transactions, we've done, I think it's the Sipla transaction, where there was ratification after the subscription agreement was signed a long time ago. I think it also it's ARC, where we did ratify the actions. So ratification is not new, you know. We've done it in IPOs, we've done it in book bills and other transactions. So the basis of doing that is because the key departments are in support of the transaction, and therefore, under those circumstances, it can be done. And I was confident that it will be ratified on that basis, Commissioner.
So ratification was assurance given. That's the point of my reading to you. The evidence was the assurance that you gave to the deal team and other staff members that gave them comfort to assist in the deal. Are you prepared to accept that?
They are not given comfort to accept the deal. They've recommended the deal. The only step that had to be done was subscription, which I authorized on the basis of a ratification. So they were not forced to do the deal. They have done the transaction, they've done all the analysis and make recommendations. The only point that was left, Commissioner, was to sign a subscription before PMC, which was not possible to put together, and therefore I undertook to call a PMC to ratify the transaction.
How do you understand this ratification situation? Let us postulate that you sign, as you did in IO, you signed the subscription certificate as you did, and the PMC that was supposed to ratify says, no, we're not ratifying. What would happen?
Well, then we'll have to sell the shares, which is not an optimal strategy.
You would be bound?
We bound, yes.
PIC would be bound by the certificate that you already signed.
Yes.
Yes, so it couldn't get out of it.
Yes.
You would have to accept the shares and sell them.
It's because it's irrevocable. Once you subscribe, it's irrevocable, and therefore signing, it's a done deal.
And you could sell at a loss. That's quite possible.
If you're under pressure to sell at a loss, but remember, the recommendation says this is a long-term investment that's going to, you know, change the landscape in the ICT sector. So we are looking at it from a long-term investor perspective. And even now, we are not, I don't think PIC should be selling at a loss, you know, because the bulk of the investment is cash that they could actually, you know, intervene and apply it efficiently. This is an investment holding. If it was a different investment where you literally get into buying an asset at that point, it's a different ballgame. There you commit and money is gone. But where you have control and you even put conditions to say if you are going to buy something more than 10% of the market cap, you must come to shareholders. Then it means shareholders are in charge of how you build the portfolio. That's what I'm saying. That money is there. It's a matter of how it's applied going forward. It's not lost. The share price that you see of 8 rands or whatever does not reflect the value that is sitting in the company actually. It reflects the noise and the hype and all the negative reports around IO, you know, as opposed to the intrinsic value that's sitting in the company. So one of the key bases here was that this is an investment where money is not disappearing. The shareholders are still in control of directing how it should be spent. That's the big difference between that and a normal company where you just subscribe and get shares and they all get into the company and gone. You know, so this is slightly different. It's an investment holding company where you're still going to build a portfolio. So there's a fair amount of control over the cash.
Yeah, but then I mean BT was a big anchor of that company, you know. What's going to happen if they can't transfer it into IO and other transactions that followed from BT, because it was a key anchor of this strategy?
I think that's where a restructuring may be required now, and the 29% becomes very handy under those circumstances, because then you are able to put together, you know, a package to solve the problem and new governance processes to be able to protect and still spend the money a lot wiser. And I'm sure if that intervention is made, BT will come to the party as well, because it looks like, according to the testimony from the other witnesses, there is a discomfort in the other players, the other shareholders in this transaction from BT side. So the 29% gives PIC a huge leverage to actually turn the company around and even brand it into something that will be attractive to the likes of BT going forward. So that money is not lost, it's there. From the last time I saw the balance sheet.
Yeah, but the PIC is going to court, you know, it's asking its money back.
I think it's a suboptimal approach, you know. I mean, unless the law has been broken somewhere and the JSE has not done its work in approving this PLS, the basis of which an investment was made. So the unwinding of that, I'm surely they are doing their own investigation around the PLS, because we were fed with the PLS, we use that as a basis to invest. So if there are issues around that PLS, there has to be a way of unwinding that position, especially now that the cash has not been spent, as far as I could read the numbers.
Okay, thanks.
Just stay with that cash not being spent at the moment, because my understanding from it is that the funding raised from IO was placed with related parties, by and large, to earn interest, and that in reality, if one looked again at an ongoing query that one would have, is that if you looked at the reporting of IO, it was the 195 million reflected as profit from 2018 is an actual loss of 31 million, as the entire profit emanated from the interest earned, which was 226 million, which is PIC money placed with related parties, such as Three Laws Capital, where 400 million was in and out, I think more than once. The income statement reflects a profit of 144 million as being from continuing operations. Is this a question again of misleading? You say you looked at the annual financial statements recently, which is also in the AO 2018 financial statements. The AFS says the group's asset base increased from 282 million to 4.671 million, which includes the capital raising from the listing. But this is also a question, the entire increase was attributable to the monies raised from the PIC. And therefore, the question for me is, did you at the time query how the capital raise was being used as per the conditions post, which includes the put option, which was then set at half the price, 22 Rand a share from 43, and if I recall correctly, for a period of 3 months only, yes. And it was only put in place much later. So for the 3-month period, it's now I don't know what it's currently priced. It went down to 3 Rand, and I think it was back at 9 Rand. So there's a lot of fluctuation in the price. But it means the conditions post were also not implemented effectively. What steps did you take in relation to seeing that this transaction actually met the conditions post, given that you could not do them for the reasons you explain, conditions prior, conditions precedent?
Well, what's important here is that we are dealing with an investment holding company. And you are right, Commissioner, most of the cash that's sitting on the balance sheet is from the listing, the IPO. PIC has put certain conditions. Put option obviously would have been difficult, and I explained that you can't have a put option in a company that is IPOing. Technically it's impossible. You have to get that from elsewhere. That's why ongoing negotiations, protracted negotiations with AEI to try to get a put option out of them were difficult. With the time running out, probably 3 months towards the anniversary of the fund, I think it must have been in late 2018 or so, we could get something on the put option. I mean, even the IC was getting very frustrated in the fact that we are unable to get a put option. And it wouldn't be surprising because it would be hard to get a put option from IO, almost impossible because it's an IPO. But my argument here is that there's an embedded put option in the company itself because of the cash that's sitting there. And that cash, as I said, can be realized a lot more efficiently because PIC is in control, almost in control with 29%. So there could be an easy intervention for the PIC to say, let's call an AGM, let's make these changes. That gives us control over the affairs of the company. That can happen very quickly and most elegant way. And as I said, it can even bring back BT to the stable and have a much better run company going forward. You know, I still believe in the strategy. I still believe in the strategy alongside BT as a strategic partner and bringing the whole platform of BT onto IO. But clearly it requires a much better working relationship, a much more strategic relationship with BT going forward. And I think PIC is sitting in a strong position to be able to do that. And the sooner they act, the better, because then they can safeguard the cash going forward. Insofar as financials of the latest financials are concerned, it's not surprising that it's interest that's shown as profits, that's lifting the profits of the company because of that 4.3 billion. You know, now that is been placed in the manner that's been placed with different banks. That's something that obviously can be dealt with by the PIC through interventions on the board so that they are able to direct the money for the benefit of the company. And I think placing money with related parties is not appropriate, and the PIC as part of the condition said there has to be a related party policy to deal with the conflict of interest policy, I think, which will include also related parties as part of the conditions post the investment. I'm sitting in a difficult position because I was told to leave on the 23rd, otherwise I would have dealt with most of these things.
But let me just ask you on that question, because this wouldn't have been the first time there would have been a related party question in investment. Did you not have a policy on investing monies raised with related parties? Was there no policy in the PIC?
No, the policy has to be with the company. We had not crafted
But
a
even then
related
from
party, how to
PIC
deal with related, you mean insofar as exposure is concerned?
Sure, but
Yeah.
it's, when you make an investment, don't you have, in terms of a standard PIC approach, what your policy is towards any funds or investment that you have in relation to related parties? Yes, of course it needs to be
Yeah,
part of the company itself,
Yeah.
but you're making the investment. Have you got no policy about related party
No, we had not
dealings?
developed that policy at that point.
No policies at
Yeah.
that point?
No.
Thank you.
My concern, Dr. Matjila, is the fact that you having signed the subscription agreement, PIC was now in it, and they couldn't get out of it, even if PMC said, no, we're not giving ratification.
Commissioner, I think you are right, that could be, but the chance of that happening would be remote, in my experience. Very remote, in my experience.
What would be remote, that ratification?
That PMC will say no to a ratification. That would be very remote.
No, that I can understand, but I'm looking at your mind at the time that you signed, knowing that PMC has not approved. So in your mind, you would have had the situation where you say whether or not they don't ratify, we're in.
No, that's not the idea. I mean, if you look at people who are involved in this, are mainly from the PMC. People just involved who's getting requests for round-robin resolutions and so on and so forth. They are all part of the PMC. So none of them has said that they have reservations around this. None of the key, what I call experts in this, have not said that they are uncomfortable with the transaction. So I did not see any risk. Otherwise, if there were indications that certain areas are uncomfortable, I would have acted differently. I've never acted against the recommendations of the team.
So do I understand you to be saying, I was absolutely certain that ratification will be granted?
In my 15 years that I've worked at the PIC, I was absolutely certain. Absolutely, yeah.
And I think you did mention previously that the people who sat on the PMC would have known that you had already signed the certificate.
I believe so, Commissioner. As I explained, the correspondence that included the signed subscription agreement and the fact that it's an IPO that we were not doing for the first time, so all of that, I believe they knew. I have a strong belief that they all knew.
My difficulty, though, is that the meeting that was supposed to ratify appears not to have been a meeting to ratify, but rather to approve. And the fact that the certificate had already been signed was never revealed, although you say you believed reasonably that they would have known about it.
I think, that matter was raised by internal audit as we have explained, because I didn't see the effect of approving post the transaction and ratification will have had the same effect, especially in an IPO. Because IPOs have got set deadlines, they've got a clear timetable as to when things happen. So once you have a meeting to discuss a disbursement and PMC on top of that, then it's clear that the deal has been done, because disbursements means that we are now paying. That's how I understood it. We are now paying. An asset has been bought, PIC has been committed, and therefore we have to pay at that point. So that's all I can say.
Can I further? Yeah. Could it be that, I mean, in that meeting on the 20th of December that, you know, people watched this and said the form has been signed and they were not happy to raise the issue and say, we are here to sort of ratify this transaction, not to approve it. I mean, do you think that people maybe were scared to say that and say, no, Dr. Matjila, we are here to sort of ratify this transaction, not to approve it? Because they knew that you had signed the form already, and is that possible that they were scared to tell you that?
I'm not sure what scares them. I'm still
because I'm trying
because people are saying they are scared.
Yes,
you know? And I really
the
don't
culture
understand.
of fear, you know, the culture of fear which prevailed there.
Yeah, no, I don't understand it. I'm still shocked because most of the things around culture of fear, you know, especially from the team that I work closely with, you know, was said in this commission, not in my face, which is strange because, excuse me, I believe I had a great relationship with them, you know, very very collegial in nature, and they could challenge me, they could tell me whatever they wanted to tell me, but I don't know, maybe the pretty low matter might have made me change into something else, I don't know. And, you know, I don't know, really. But all these years that I've worked with most of them, we've never had any challenge in opening up on matters in the manner that we should.
Yeah. See, because I find it hard that with the disbursement, they would probably know that this is a done deal, all right? But then in that particular meeting, why didn't they say, no, this is a ratification, it's not a approval? So I'm just trying to understand. I probably agree with you that they probably did know that this deal has been done, you know. But why didn't they raise that in the meeting when you talked about approval versus a ratification?
Look,
were they scared to raise the issue or not?
I have no idea why, quite frankly. I can't answer for them. As I say, I'm surprised.
You see, Dr. Matjila, you were in that meeting, and you knew that this is not an approval meeting but a ratification meeting. You knew that you had signed the certificate, and that's why you wanted ratification, and the disbursement document had already been signed. And the question is, I did ask you this question before, why then did you not correct the meeting and say, no, people, this is not an approval meeting but a ratification meeting? Particularly if you believed that everybody knew by then that you had signed the form.
Commissioner, maybe I should have done so, but I never thought there was going to be a problem until it was raised by internal audit. I didn't see any problem with that, really, to be honest. I thought, you know, approval, ratification in an IPO would be similar because IPOs are special, as I say. Once you sign an irrevocable that everyone knows has been signed because you are dealing with disbursement, then the effect is more or less the same. You know.
And as far as you are concerned, there was nothing untoward with the process from risks, etc., except for the fact that there had not been a PMC, call it PMC1.
Absolutely, Commissioner. As I have explained, I was comfortable with the fact that the work has been done in terms of the key things that we need to look at in making a decision of that nature have been done. And we've made attempts to get the PMC together, but without much success. And responding to time pressures, we had to deal with the issue the way we dealt with, on the basis that we will regularize the process at some stage, at whatever PMC we can get at the later stage. So I didn't see anything wrong at all. And on the basis that the risk in terms of the asset itself, investing in this kind of assets is different from a normal asset, as I've explained, that the cash is to be spent and the shareholders have control over how it's done.
And you accept the fact that you signed the subscription certificate at least one leg of the process not having been adhered to, and that is PMC1.
Commissioner, PMC1, we've explained that in IPOs it's not necessary, in the sense that we are not spending money. What is very important here is that we've hired professionals, people like Victor Siane, who are chartered financial analysts and also representatives. They have authority to perform certain functions, and they cannot be straitjacketed by processes where literally, instead of being proactive, they have to sit and wait for a PMC1 to be called when the information is in front of them that they can perform. So the organization has been successful because we've allowed people to be creative and freedom to test ideas and do things and be proactive, So I was shocked when I was told that one of the allegations against Mr. Siane is that he instructed ESG, legal and risk to start working on their reports before PMC1. The standard operating procedures were not designed to straitjacket people. They were simply designed as a guide to say, these are the steps, and in instances where it's not necessary to do so and can be justified, it does not have to follow standard operating procedures as they are. But there are certain steps that cannot, especially PMC2, that cannot be compromised. But PMC1, depending on whether we spend money or we don't spend money, that can be not done with, not complied with.
Wouldn't someone have to give them instructions to do what they should do?
Commissioner?
Shouldn't they get instructions from someone to do what they're supposed to do the investigations?
Yes. I would expect that Fidelis Madavo, because he was the one leading the investment, would have given them a go-ahead to start the process. And that's my understanding, that he gave them a go-ahead to start the process of analysis.
Would a ratification of the fact that PMC1 was sidelined might be a wrong term, was not complied with, that step was not complied with, would that require ratification?
We do. And I think there are proposal to that effect. I think there are recommendations that be waived, in the same way as it happened with I think it's one or two transactions. CIPLA is one of them, if my memory serves me well, and African Rainbow, where a step, PMC1 step or pre-due diligence step has been waived formally by the committee through a round-robin resolution.
Are you saying that you are recommending that step be bypassed? You say there are recommendations to that effect. Are you recommending that they be bypassed?
Depending on whether...
And of course the follow-up question would be, if it may well not be necessary at certain stages, then why recommend now?
Sorry, Commissioner, I'm losing you there. I'm trying to...
I'm losing my voice. I was asking whether if PMC 1 was not complied with, if that step was bypassed, would ratification for that omission be necessary? And I think you said yes, and then you carried on.
Yes.
And now later on you said something about in the recommendations there is suggestion that PMC 1 may be done away with.
Oh, no, sorry, Commissioner. I was making an example of other transaction where PMC 1 was ratified post. Yes. I think PMC 1 will remain. It's only ratification under certain circumstances. And it has to be clear that what those circumstances are. The main one being the fact that if money is not going to be spent and there is information available, as is the case in an IPO, then PMC 1 is not necessary. But at the same time, I'm sure the issue is going to be what have we learned from IO in particular in terms of the PLS, reliance on that, based on what we know now, according to the other witnesses, what does it mean under those circumstances? So the processes may have to be adjusted to also include the learnings from the IO transaction.
One last question on the aspect from me. There was no ratification, or was there?
I think
for missing out on PMC 1.
There was a round robin resolution of the 13th, I think the 13th of December. So there was, the 6th couldn't happen, but the 13th there's a memo that requests the waiver as well.
Sorry, to stay on the same question. Given your assumption, because it must be an assumption that everybody knew, surely when you come, everybody knew that there had been an irrevocable signed and that the payment authorization had been done prior to the meeting. Surely when you sit at a meeting like that, somebody who's in the chair, and I think if I recall correctly, Ms. More was in the chair, who knows that she had also signed, and she said she wasn't validating it, she was just saying the money's there in her testimony. The question for me would be, surely at the start of a meeting you set out the purpose of the meeting. We are meeting as PMC to approve the IO transaction in which an irrevocable has been signed, the finance has been authorized, and we are here to approve that. Was that you were present at the meeting? Why would that not have happened given the consequence to individuals, including Victor? And in Victor's testimony, he says, I was very shocked to have been handed a suspension notice. This is very unexpected, as I'm a very small player in the bigger scheme of things in the PIC and in respect of the IO transaction. And yet, he was suspended on the basis of not disclosing and of starting the due diligence without being authorized by a PMC 1 to do that. So his suspension has been an outcome of a non-disclosure by yourself and Ms. More at that meeting to say, this is where we're at, we've had these reports, this is what the situation is. And that's all the more important if we go back to your paragraph 245, 246 in your testimony, where you're dealing with Ms. Matjila, and you indicate there that she states, when asked, I stated to the board that my view was that the matter was a whistleblower allegation and should be treated as such. We're talking now about the emails, not about IO. However, it is worth noting by this commission that Ms. Matjila was very much involved in the approval process of the MST application, etc. She knew quite well that
due process was followed in approving this application, but chose not to disclose to the board that due process was followed. Ms. Matabula's non-disclosure above and her testimony before this commission, in which she launched a scathing attack on the PIC board as to the manner in which the allegations against me were handled, portray her clearly as one of those who gave credence. She has an alliance with Ms. Zulu. It mattered to you that there was a non-disclosure. I'm not questioning this, I'm saying it mattered to you that there was a material non-disclosure. And yet when it comes to the PMC, you're saying, well, I assumed everybody knew, and yet that material non-disclosure about decisions that had been taken prior to the meeting has had consequences for a whole range of people, including Victor Siani, and the knowledge. Why would you as CEO and Ms. Mora as Chair and CFO chosen not to disclose, even if it was a point of emphasis or clarity, to say, let's bear in mind that we all know this is an IPO, this is what has been the state, therefore we are ratifying, not approving.
Yeah.
It's just questionable to me why there was non-disclosure, why it would be an assumption when you've gathered as a meeting to not put the purpose of the meeting on the table.
Look, I think the key word there is when asked. So somebody wanted to know. In case of Victor, Victor was not asked. I remember he presented the whole investment proposal by himself, but that's probably the difference here.
But you were there, and I would assume that given Victor's, the hierarchy, the structure, if you were present, I would assume from a Victor perspective that it would be something that you or Ms. Mora, who have signed the things, who have dealt with it, would be the ones to tell. If he was not asked, as you're indicating, specifically about it, then is silence on your own terms material non-disclosure?
Yeah.
Right? So there is material non-disclosure because he was not asked, but he did not say. But neither were you asked or Ms. Mora asked, and therefore there's material non-disclosure on your parts, if that's the argument. You're there for that purpose. What I'm lost in, that's the purpose of the meeting, was to do that.
If you assume that no one knew, then it's fine, you can do that.
I'm not assuming that. Don't get me wrong.
No, I'm saying if someone assumed that no one knew, it's different from if you assume that everyone knows, because Victor has sent out irrevocable agreements, emails and so on, that an irrevocable has been signed ahead already on the 14th to the relevant people.
But that's precisely the question. Ms. Morris said she didn't open her email, she wasn't aware. So the question I'm asking is not about whether somebody knew or the assumption that you knew. When you're having a meeting of that nature, why would it have not been put on the table is my question. Why would you assume everybody knows why we're here, let's just sign off, we don't have to have a meeting or a discussion? Because that's the implication of it. And both of you know, so just for points of clarity, we're here to do the following. Everybody knows where you stand and what the purpose is, because if you're approving a resolution unanimously, as you say in 457, unanimously approved the investment in IO, was it taken with full knowledge, stated in the presentation to everybody present, we are approving this, this has been done, this has been done. Because what it seems to me is that there was not disclosure about the two critical factors that would make this unanimous approval without a doubt, with full knowledge of what the steps were. There's an assumption that everybody knew. It's not clear to me as a person reading the statement that there's a unanimous agreement on approving it with full knowledge. You in the meeting may well have had that full knowledge, but surely was it not on the table?
But so was a lot of people that were sitting in that meeting, because they've been sent emails that an irrevocable have been signed. And this by the 20th, and the basis of that meeting on that day is to discuss a PMC to give effect to the disbursement.
But the disbursement's already signed.
It's being regularized in that meeting, that's the 20th.
I understand
The
that.
money has not flown, it's in that meeting. that the disbursement is being, and I was comfortable because I said that a next meeting will deal with the matter. The next PMC will ratify. So, fortunately, I was in the vicinity when Ms. Murray on that day decided, let's have a meeting. Let's have a special meeting immediately. So this meeting was called at short notice as well that day, I remember.
Yeah. I don't think I can take it further.
If I may be of assistance, Dr. Matjila, the question of ratification is in fact predicated on full disclosure on your part as the person who decided to sign the irrevocable subscription and the person who decided to get ratification. As a matter of principle, you bore the fiduciary duty to disclose. Would you like me to repeat that?
Yes, please.
You bore the duty to disclose at those meetings that the irrevocable subscription had been signed, and so it can't be a matter that's left to assumption. You bore the fiduciary duty to disclose, because ratification by implication means seeking endorsement of something you've done retrospectively, but giving full disclosure.
Placing the full facts before the meeting.
That is correct, Mr. Commissioner. In fact, I've got an extract here from Willie's Principles of Law. It says, if B, in this case yourself, Dr. Matjila, without express or implied authority, enters into a transaction on A's behalf, PIC/PMC, A, PMC, may, at a full disclosure of all the facts, ratify the transaction. The ratification may be express or implied. The effect of a valid ratification is to cloak the agent's unauthorized act with authority retrospectively establishing the relationship of the principal and agent after the fact, that with retrospective effect, with the usual consequences of agency. You bore the responsibility, you bore the fiduciary duty to disclose. It's not a matter of assumption.
So is everyone else in that meeting?
No, it's the CEO whose decision it was to sign the irrevocable subscription and seek subsequent ratification.
The people in that committee knew that the disbursement is being processed. That's why we had the meeting. And my understanding is that even this irrevocable subscription form was attached. Victor says that the emails were sent with attachment of a copy of a irrevocable subscription that was signed. And I was at pains to explain that this is an IPO. It's got set timetable. And so everyone should know that we are dealing with an IPO with set timetable. And it was not the first time that we're doing an IPO at the PIC.
Would you say on those facts that Victor should never have been suspended? Mr. Siane should never have been suspended?
I totally disagree with what has happened, especially if it's on the basis of standard operating procedures, which I believe are the CEO's responsibility. When those deviations happen with the CEO's consent, I don't see why it becomes a problem, really. These standard operating procedures are designed by the CEO to make sure that there is process, also helping in things like business continuity. A new member coming in will know that this is how things work. But these processes are not cast into stone. There will be deviations from time to time depending on circumstances. And the CEO has full authority for that. This is not a policy. It's a process document that we're talking about, a process. And you can even see that it's signed off by Mr. Madavu. I just checked that it's good enough to comply with certain aspects of how we operate. It doesn't even go to the board for approval because it's within the powers of the CEO to make sure that it's there and he has authority to override as and when it's necessary. So I disagree with the fact that Victor Siani and others were suspended on the basis of not complying with certain aspects of the standard operating procedures, under the supervision of the CEO for that matter.
Yes, just tell me a question here. Who actually signed the payment memo, the disbursement memo? And when was that signed? Because in that memo, it says there that we shall ratify these transactions on the 20th. So one would probably assume that anybody who saw that memo would know that. But maybe those who didn't see the memo, it could be a different story.
It was signed by finance, legal, myself, and risk. All the key departments that are involved in the transaction, including the investment team. Of course, it was initiated by Mr. Siani, if my memory serves me well. But it will go through.
Yes, we have it. We need to just check who actually signed that. Because it does say this ratification, but we just have to, and can we assume that they would know that? Can we safely assume that? That is another big question. Can we assume, or you should have said it again in that particular meeting?
Well, I assume that because the memo is clear, once you talk about disbursement, the first thing you think about, what are we disbursing for? Money has been spent and it's an IPO. It's clear that throughout the correspondence from the 6th to the 13th, 14th, everyone is informed that this listing is going to happen, and these are the timetable and key dates for that, including the payaway, which is the disbursement after signing any revocable. So
yes, because it's a bit of a conundrum in the sense that people signed that. Can we assume that they knew it was a ratification meeting or not? You know, I mean, it's given that they have signed the disbursement memo.
That's absolutely what I understood.
But of course, there was no ratification at that meeting. The ratification came afterwards, isn't it?
That's correct, Commissioner.
Yes. Now, which means that everybody there thought that it was this meeting was for an approval. But in any event, did everybody who was at that meeting, at that approval ratification meeting, sign that disbursement memo?
Commissioner will have to check, but the key departments, because sometimes people are on leave and they not delegate to someone else to represent them, especially during that time of the year. There's a lot of movement, so the offices become very important here. We can talk about offices, and we expect the handover of some sort to happen when somebody takes over as acting on critical things that they need to be aware of.
Now, all I want to be sure of is whether everybody at that meeting knew about the signing of the subscription share certificate, so that one can say, well, everybody at that meeting did know and so ought to have known that this is ratification meeting.
Yeah. Commissioner.
Can this be a convenient time to take the tea adjournment?
Thank you, Mr. Commissioner.
Until when? Until 12.
I just want to fill with my document. PMC, requesting that the PMC notes and ratifies the participation in the AO private placement due to the fact that at the meeting of the 20th of December 2017, their PMC was not notified that on the 14th of December an irrevocable undertaking was signed. She was the chair of that particular meeting, and this was her statement, which is different from what you're saying that everybody in the meeting knew about the irrevocable. How would you interpret her statement?
Well, it's her statement. I think I've put together my facts across, Commissioner, and we're going to look at the disbursement memo and who was present there. She was there. If you look at the disbursement memo, people who signed the disbursement memo, for example, it's Mr. Siani, Mr. Hanewe Adams, she's aware, Mr. Smith, who's representing Mr. Madavo, who's head of listing, of trading, Ms. Tsedi, Mr. Mavuga, who's also GM of finance, Ms. More herself, and myself. This is a disbursement memo, so they knew, she knew that the deal has been done, because as I said, disbursement means that we are paying. That is my understanding. And it's an IPO. An IPO has timelines. And the key reason why she called that meeting, that PMC, was to regularize this payment, actually.
So the question that then arises, who's there from risk, from the list that you were talking about there?
From risk, this is a disbursement memo, so risk wouldn't be part of this.
Okay,
They are not copied. It's only legal, because legal has to sign off on any conditions, precedents or whatever.
Well, there were no conditions precedent, as we know.
Exactly.
Was there anyone else in the PMC meeting apart from those who signed the disbursement memo? Were all of those people in the meeting?
In
or who was in the PMC,
the 20th
meeting? Who was present at the meeting of the 20th?
Ms. Mori?
Well, Ms. Mori was chairing.
Ms. Mori was chairing. Sure. Myself, Mr. Smith, Mr. Tsedi, Ms. Adams, Mr. Siane, of course, Mr. Ukubo, Mr. Nzaza, he's the one who was supervising the signing of sign-off of a risk report.
But he wasn't there, he wasn't on the disbursement list? Mr. Nzaza was not part of the disbursement list?
Yeah.
No?
So those will be the people who would have been in the meeting of the 19th, as well as the Portfolio Management Committee meeting.
So the only person there who was not part of the disbursement was Mr. Nzaza?
Would be Mr. Nzaza.
And
Mr. Nala,
okay,
representing research. Ms. Muloi would be representing GM externally managed funds.
So those three people why would you have assumed they would know the irrevocable has signed?
Because I would expect them that there's an handover when they are giving
the authority. So it's an assumption on your part?
Yes, and it has to be done that way. Otherwise, they don't have to be in meetings.
But
they also receive all documentation about the meeting.
But Ms. More says in her statement that none of the fact that the irrevocable was signed was not disclosed in those documents that came to the meeting.
She was chairing the meeting. She should have told the meeting that there's an irrevocable signed.
I'm not disagreeing. I'm saying both of you were in the meeting, and that's the whole point, is you're asking for an approval of something and not a ratification of something that clearly was the elephant in the room that nobody was asked about or told about. I mean, that's the whole point of this discussion, is to say, why was there... A very simple question of all of this would have been, colleagues, we are here to have this is what's been happening, this is the status, and we're signing off, we need to ratify this. Instead, it's an approval, and when you come to the actual PMC to ratify, that's 5 months later. So clearly there's a lot of misunderstanding about who knew what when over this matter of IO, which was a very significant investment. I think that's what we're trying to understand, is in a meeting of that nature, which has had consequences of people being suspended, etc. There was a simple question of people in the room knowing and putting that on the table.
Yeah. I think we're at length explaining IPOs and the timelines, and that people should have known. I expect everyone to know, because it was not the first time that we deal with IPOs, quite frankly. So I find it very difficult to accept that people didn't know.
Another, just
Even
another
the investment committee accepted our explanation, actually, and instructed us to go and fix the ratification, that approval into ratification.
Just another point is that it looks like the minutes of the meeting of the 20th still spoke about approval, and they still were signed based on approval, you know. So I mean, why didn't people correct the minutes? And all,
I don't know when the minutes were done, and I think that those were signed by the chairman, I guess, because he's the one who's supposed to make sure that the minutes captured the discussion of the day, you know. So I think the 10th of May as well, it's clear what I'm not sure if we have the 10th of May Portfolio Management Committee. So it says that PIC internal audit highlighted the semantic mistake made in requesting approval from PMC to participate in IO private share placement. The intention was in fact to request notification and ratification of the transaction from PMC.
all right.
So the minutes should have captured that too. You know.
So are you saying the PMC then said it was a semantic, it was not a ratification of that meeting? It was more a correction of the wording and all.
It was a correction of the wording.
Yeah. Yeah, the so-called sort of ratification meeting was a correction. It wasn't a meeting to ratify that transaction. It was more of a wording correction. Is that
Yes.
what I'm hearing?
Yes, because we're correcting the wording that was supposed to have been ratification as opposed to approval.
But that takes nothing away from the fact that you, at least Mr. Siane, I'm not sure about the person who chaired, knew at the very time that the meeting started that this is supposed to be a ratification meeting, a place where that should have been corrected there and then by people who knew that all we want is ratification.
That's correct, Commissioner. That's correct. I think it's very important also to read out the minutes of the IC meeting of the 8th as well. On 6.2.4, it says approval and ratification of PIC's participation in the private placement were obtained at a special portfolio committee unlisted meeting of the 20th, after which the funds were disbursed on the 22nd. Approval of the transaction was obtained in line with the delegated authority. The IC was happy with that. Actually, I was very surprised that IC accepts, and then later on in December, a new investigation is launched, which reminded me of MST. It looked exactly like MST. MST, we went through the board of the 15th and explained ourselves, and I was exonerated. The board agreed with my explanations. And then later on, the board's decision was undermined by someone else who decided that they erred and therefore this must be done again. And PIC went on to spend millions and millions on a new investigation of the same thing, that in the end corroborated the decision of the board. Here again, we see the investment committee agreeing as the body that was tasked with by the board to investigate the IOMET after the media reports, and it accepts that, and then later on, after having approved and instructed us as PMC, that management, to rectify the problem, then this matter is raised again. So it's almost similar, that it's a body that has authority to approve the actions of management is then undermined with another process on top of that. I thought I should just make a statement.
I just want to remind Dr. Matjila that it's not that anybody is after you in this commission, but one of the tasks that we have been given is to investigate whether the PIC's processes were followed and followed correctly. That's what we are trying to get to. I don't expect an answer, it's just...
Sorry, Chief, did you want to say something? Just to again go back to Ms. More, because there is an important difference in between ratification and approval. I think we all understand that they're not the same thing. Even although you initially were using them interchangeably, they are not the same thing. And just to come back, she says as a point of emphasis in 611.2, I highlight that the irrevocable undertaking was not one of the documents that served before the PMC meeting of the 20th of December. By saying this, by implication, although she has signed off on the disbursement, she is indicating that the irrevocable was not on the table and by implication did not know about it. But she then says, after deliberations of the outcomes of the due diligence and the IO transaction itself, the committee resolved to approve the transaction subject to certain conditions, and the conditions are the conditions post, as we know, and that took time to put in place. So clearly between the two key players, the CEO and the CFO, over this deal, there was some lack of communication or misunderstanding about what was actually the purpose of that meeting. Because again, the committee resolved to approve the transaction.
I think, Commissioner, if you understand that this meeting was triggered by the fact that the disbursement memo was being signed.
I understand that.
And she called the meeting and then she chaired the meeting. So Siame had already sent out information around the fact that the deal has been done. He prepared this disbursement memo because the deal has been done. And the CFO, when he had to sign, she said, well, let me call a meeting to fix and ratify as we were supposed to do so that it can give effect to the disbursement. So for me, I don't understand why she wouldn't have known that the transaction has been done. And I keep saying there's disbursement. Disbursement, it's about now you are paying funds for something that you have acquired.
All I'm indicating is that clearly between the two of you there was some misunderstanding about what was happening, because she said all she was doing was indicating that funds were available. That's what I recall her saying in our meeting. And then of course you did have to do a letter to the JSE, which also had to be done indicating that you would liquidate certain assets to enable the payment to be made in 2 tranches. So clearly there was a lot of interaction between both of you over the matter. And the question of approval ratification is one aspect, but what we're asking for the purpose as pointed out by the judge is the processes in the PMC meeting where not all the people there were part of the disbursement memo. Did they know what they were there for? Did they know that there had been an irrevocable signed? And that's what we're asking you as the senior person in the room to say. To me, what I just don't understand, when you start a meeting as a chair and a CEO in the room, what the purpose of the meeting is, surely that would have been absolutely clear. We're here to, this has happened, and this is what we are going to ratify or approve, or whatever it was. That's where the disjuncture or the discordance lies between the testimonies given by others and yourself as to what the purpose of that meeting was, in terms of the process of the PIC being followed. Well, I mean, it's no, you've got a view and you've presented to that committee, to the commission, and that's part of our consideration in due course about what is before us. You can't correct Ms. More and she can't correct you. You've got your own testimonies about that, and thank you very much, because that is, all we're pointing out is the discrepancy between what she said and what you have said.
Just a question here. Can I please get that annexure on that semantic error which you sort of referred to? What is it? What date is that? 8th of...
It's the 10th of May 2018.
10th of May.
So it's a memo by the PMC.
Okay. All right.
But just for the record, it's not semantic between ratification and approval. They're vastly different. It's not a semantic issue.
It's described as a semantic.
No, I understand that's the minute, but what I'm saying is that there's not a question of semantics in this.
Okay, Commissioner.
No, the two are fundamentally different.
Yeah. And then the second question is, do you typically attach the subscription form to the disbursement documents? Because, I mean, if you have to pay something, at least there must be some supporting documentation.
My understanding is that that was attached. It has to be attached to show that there is...
Was it attached?
A deal has been done. That's my understanding. I didn't see the full pack, but that's my understanding.
We need to just double check that, because if it was attached, then people would know that there's a subscription form and it has been signed.
Yeah, but also we also have to check other transactions because it's not necessarily standard practice within the PIC that you attach the whole documentation, rather, because we rely on the team to do all the work and advise us on what needs to be done.
Yes.
So I would be surprised that a subscription form will be attached. Only clear measures to say a deal has been done and payment has to be done on this day. But that can be checked.
We can check that, yeah. And especially for finance, maybe for the others, but probably for finance, they might say, we cannot have this payment memo without the supporting documentation like the subscription form, at least for the finance department.
Yeah.
Would you agree with that?
Repeat the question again.
Is that the subscription form, could be attached when it goes to the finance division, because they would need some supporting documentation.
That's I would expect
so
that to be
just have to double check that to see whether finance at least saw that PLS, that subscription form.
Yeah.
Advocate MAP. Yeah, if we can check that.
But they must also check others. I mean, like CIPLA. I know CIPLA was similar.
Yeah.
There was a ratification, post. And the disbursement memo, I don't believe it would have included other things. It's only a message to say that PMC has approved and therefore disbursement has to be done. Sometimes they would send a resolution of the PMC as part of that, but when the PMC has not been done, it has to be handled differently.
All right, that's fine. Mr. Mohapi, back with you.
Thank you, Mr. Commissioner. Mr. Commissioner, I intend to move on to another topic, that of the delegation of authority. Dr. Matjila, if you can please have a look at the delegation of authority for listed investments. I believe that's D 14.1.
Sorry, was that 13.1 or 14.1?
14.1. Thank you, Mr. Commissioner. Now, Dr. Matjila, we, on the last occasion, spoke at length about your authority under the delegation of authority to approve deals. And you mentioned that you enjoy authority under 8.1.2. Can we please turn to that? And you said that you enjoy authority under that provision to approve this particular transaction, correct?
Commissioner, I don't think if I had applied 8.1.2, we would be having a problem discussing IO transaction. And I explained that I didn't use this, so I prefer the other one because it's much more inclusive.
Yeah. Now, I want to demonstrate to you what I said on the last occasion, that in law context is everything. If we look...
Can you just quickly get clarity on when you say the other one, which one is that?
5 point, section 5. 5.1, 5.2.
Okay, so we'll get to 5.1, 5.2, but just to deal with 8.1.2. 8.1.2 is under portfolio trading and strategic stocks, is it not?
Yes.
And that is a subheading under listed equity domestic markets. Correct?
That's correct, yeah.
That is not private placements or IPOs, is it?
It don't include IPOs because it's strategic. We said we are taking a 29% position in IO because it's strategic.
Okay, we'll get to that. Then also, you speak about 5.1 and 5.2. That deals with derivatives and risk management, equities, derivative overlays, including currency rebalancing, tactical allocation overlays, correct?
Sorry, I've quoted the wrong one. It's section 6. That's section 6, sorry. Apologies, Commissioner.
Yes, section
6.2.
6.2 also deals with Africa, non-domestic strategic investments, including sign-off of legal agreements. Not so.
Sorry?
The heading under which you mentioned 6.1? 6.2.
Section 6, yes.
Yes, that deals with Africa, non-domestic and strategic investments. That's not what we are dealing with here, is it?
Let's not deliberately ignore section 6 that says Africa, non-domestic strategic investments.
No.
And then A says South Africa and Africa.
But is there a provision in the delegation of authority, Dr. Matjila, that speaks directly to private placements?
No, because they are part of listed investments.
Can you turn to section 12, please? Now, section 12 reads fixed income and dealing, and then it's got a dash private placements. Not so?
It's fixed income private placements, not equities. These are private placement in fixed income.
No. And then if we look at 12.2, it speaks about you having the authority but with PMC approval under that.
No, but 12.2 is irrelevant. We are dealing with equities.
But this is the only provision that deals with private placements. How do you reconcile this with domestic markets in Africa, non-domestic dealings? I mean, we're talking about markets, portfolio trading and strategic stock.
Commissioner, this portion of the delegation of authority deals with fixed income. Section 6 deals with equities, including Section 8.
Yeah. Mr. Commissioner, I'm sorry to interrupt my learned friend here, but is it really being suggested that the PIC, that there was no authority on behalf of the PIC to enter into an IPO?
I think it would be better to point at something and say, there is the authority.
We said the authorities under listed investment. There is Section 8 dealing with strategic investments, and Section 6 covering Africa, South Africa, and many others in the equity space. Those are the two sections that are dealing with direct equity. That will include IPO, it is assumed.
What I find strange, Dr. Matjila, is that you've got the term private placements under 12, and which there shows that you don't enjoy the authority you say you have. And there we're dealing with trading and stock. And IPO is a vastly different concept, isn't it? Because here we have a new entrant to the listed space versus trading in already listed companies. Is that not so?
Well, I really don't understand the issue here, because I don't want to mix Section 12 with equities because it's for fixed income. I think we need to agree that we are going to disagree on this one. Equities provision is in Section 6 as well as Section 8.
Listed companies trading in stock versus IPOs, those are two vastly different things, are they not?
I don't understand the nature of the question and what it's intended to uncover.
Sort of, isn't it that in fixed income, private placements are regular? You know,
it's almost every week.
Yes,
you would have that.
Yes, that they play stock all the time and all that. So it's vastly different to an IPO on the equities section. I'm just trying to see, you know, in fixed income, a private placement is a vastly different thing to the one in the IPOs in the equity sections, as far as one understands.
I accept that, Mr. Commissioner. Yes. And another point, Dr. Matjila, that I find interesting is, and this is on the premise of acting within the strict confines of the delegation of authority. Under Section 17, dealing here with nomination of board or investee companies, it's got an interesting provision there which enables you to do that which you've done under AO but you didn't. I mean, that which you've done but which you couldn't under the delegation of authority. And that is under that provision on nomination of board of investee companies, it says appointment of PIC employees and or external persons to sit on boards of investee companies. And then in italics, in urgent instances, the CO to approve subject to DAC ratification. And DAC, as we know, is the Directors Affairs Committee. One would expect if there's a provision such as this in the delegation of authority, you would have a similar one where the board has anticipated and wanted to give you that authority to sign an irrevocable subscription and then get ratification subsequently. Not so?
I think, Commissioner, probably these are some of the ideas that can be thrown back to the PIC board to enhance the delegation of authority. If there are areas where it's not clear, maybe one of the takeaways from this commission is to fix certain aspects of it that are not clear.
Yeah, but it's no simple or it's no little matter for a CEO of a 2 trillion asset managing company to do things outside the delegation of authority and to interpret it loosely and fastly, is it?
I don't think I've done so. I don't agree with what the evidence leader is saying. I think it's not appropriate. I don't feel happy or comfortable with what he's claiming here. I think I've acted within the delegated of authority as far as possible. I've applied it as it's supposed to be applied.
All right. Just to ask differently then, I mean, and I'm sure he's probably looking at that too. Did the DOAs prohibit you from taking the action that you took on the IO transaction?
No, I don't believe there's no way it prohibits me to do that.
Yeah, because it can be fixed, but you know, in future. But did in any way prohibit you from undertaking?
I think the fact that even IC, you know, did agree or instruct management to go and fix whatever problem there is, and most importantly said what we did is within delegated authority of management, of which the CEO, I believe, is in charge of, according to delegation of authority, that he's responsible for day-to-day running of the institution, including third-party funds. This was just part of that role that he plays as management of the third-party funds.
Yeah. So you're saying, are you saying it could be a gray area then?
There may be gray areas. I mean, otherwise, I guess we wouldn't be here and debating this.
If it was clear enough.
It was clear enough. So the fact that we are here is because there is a gap missing that needs to be fixed. But I believe that I acted within my delegated authority as I'm supposed to.
Continue, Advocate Moore.
Mr. Commissioner, I intend to move on to a different topic.
Question, just in terms of the DOAs, are they policy? Are they, you know, you mentioned like systems and processes in terms of the SOPs, standard operating procedures. But in terms of the DOAs, what are they? Are they policy that you cannot sort of contravene and all?
Absolutely.
Deviate from and all that, yeah.
Yes. The delegation of authority will be a policy of the board. It's owned by the board. It's the one that gives authority, delegate authority to certain functions so that the organization can run, you know. So it's a very important policy document for an organization.
And hence then you are saying the action you took was sanctioned by 6 point what? Is that the Africa?
6.2, the...
Yeah. Sort of, are you happy that that section actually is clear enough to say you could have taken that action?
I think it's clear. It is clear.
Because it says strategic investments.
Absolutely. It talks about strategic investments.
But on the IO transaction, would you say it was a strategic investment or it was just an IPO that you sort of had to participate in?
I think if you remember, we even showed where it's located in the bigger portfolio structure. It falls under ICT services. You know, people talk about fourth industrial revolution and so on. So ICT is one of those sectors that are expected to drive economic growth. And as part of a developmental investment, you know, it sits there.
Yes. Yeah.
And the strategic position is a size that gives us leverage to influence strategic direction and certain major decisions that the company can take.
Yes.
Yeah.
Yeah, but then 6.1 says strategic investments listed amount greater than 10 billion rand. I mean, IO was 4.3 billion rand.
Yeah, so
6.1.
That will be for, 6.2 will be for PMC, as you will see. And 6.1 will be for IC, I think.
Oh, I see. Okay, so
Yeah, it's a different limits for.
between 3 billion and 10 billion for
Absolutely.
for the current amount. And you say 6.1 would be for what?
6.1 if
Would
I
be
go
for
to
the PLC. Oh, yeah. Okay. All right.
So 6.1 will be for IC.
For the IC, yeah.
And then 6.2 will be for PMC, and then the next one will be for the CEO.
Okay. All right. Okay. And you say this section then did empower you to
Yes.
to do the 6.2, not
6.2.
6.1.
Yeah, 6.2, Commissioner.
Okay.
That's why the issue of ratification kicks in,
Yeah.
because it's PMC authority.
Yeah. And then it says B, 6.2 says B, and then the CEO must agree
Yeah.
beforehand.
Yes.
Yeah, the CEO. And the CFO. And the CFO, so meaning that, yeah, the CFO, didn't agree to this thing.
Sorry?
The CFO didn't agree to this transaction because she didn't know where the subscription form was.
But the PMC approved, which you chaired on the 20th.
Are you relying on the PMC on the 20th to say that it approved your signature of the subscription share certificate?
Commissioner, I think we need to understand the process. It's not normal that I will go to each one of. By the way, if I were to do it this way, if we were to follow this, then it means I don't need a PMC, actually. All I need to go to certain people to say, do you agree this, do you agree with that, do you agree, and so on. But that's not practical. The agreement, for example, the initiators will be the guys who are preparing, the team that's preparing the actual submissions, whether it be the listed team, investment team, team of professionals, the ESG, and so on. They are putting together as part of the initiation and present that to the PMC, where we sit and decide on their recommendation, and that agreement comes out of a meeting or through a round-robin resolution if we can't meet. So the only instance here of the IO in particular was that we couldn't meet to do that, but all documentation has been sent. So ratification was sought on the basis that the key departments would have done their work and recommend the transaction. And then seek ratification at the first meeting that we could get.
I think I need to understand this properly. So, in what circumstances can you, without the PMC, two? Unfortunately, I've got to refer to these 1 and 2s. In what circumstances can you approve by yourself, of course with the consent of the CFO, and a matter, it is not necessary for it to go to PMC?
If we were to apply this strictly, it will probably be section 8, more or less, or 6.3, if you will, where there's a lesser amount. I just have to consult with the, so it's really the issue of size that then requires PMC approval. If it's 3 billion, then I can do it directly, but I don't remember doing a transaction in that way. We've all attempted to do the full process of PMC.
Yes, but you still have to have reports from
from different...
different parts of the organization.
Absolutely,
Risk
because...
department and etc.
Absolutely. Even if I have full authority to sign off without calling a special PMC, they have to have done all this work. An investment case and recommending that the transaction can be done.
Just in terms of 6.3, you can do these transactions without PMC, yeah, but you need to beforehand, I think the CFO and the executive head of listed should agree to it. It says B and B for those ones. It's CFO and it's the head of risk actually, yeah. Those are the two that the DOA say that you can do these transactions below 3 billion without the PMC, but you got CFO and sort of head of risk to agree to that.
Yeah,
6.3.
That's what it says, but in practice, we've just followed 5.2 in most of the time. There's never been a situation where we get a transaction, it gets done by the team, and then we don't have a PMC to deal with it.
Yes.
The way it should.
Oh, I see. So,
Yeah,
then you do, you do the PMC, but this is within structured investments.
No.
The 5.2. That's structured investments.
I keep referring to the wrong.
Yeah.
Apologies. I think we are dealing with section 6.
Section 6.
That will be section 6.3. Apologies, Commissioner. But it's the same. It's exactly the same.
Sorry, it's section 6.2, which deals with strategic investments for amounts greater than 3 billion, but less than 10 billion.
Yeah.
That's what you need PMC approval for.
Yes.
And section 8.1.2 is purchases or disposals greater than 3% but not exceeding 5%. That's what Dr. Matjila could do with the agreement of the CFO beforehand. So it's those two, 6.2 and 8.1.2. 6.2 is PMC, 8.1.2 is CEO.
Yes, but then it means that the process which was followed, the normal process followed, is not catered for in the DOAs then. Am I correct? That, you consulted, you can't do something without the PMC, but if you look here, it's not catered for, broadly.
I thought 6.2 does cover that, Commissioner.
6.2 says that you still need to consult the CFO and the sort of head of risk. 6.2.
Yes.
You don't have to have a PM. No, there must be a PMC.
There must be a PMC.
In 6.2, but in 6.3, actually something below 3 billion, there's no need for a PMC.
That's correct. That's correct.
Yeah, but that's 4.3 billion rand. So meaning that you were on 6.2.
Absolutely.
Then meaning that you should then consult with the CFO and and there was supposed to be a PMC.
Yeah.
Also.
So the PMC couldn't happen because 13th was cancelled because people were not there. 14th, round robin couldn't work. And then the 20th, after signing the irrevocable on the 14th, the 20th disbursement was supposed to take place, which was the memo of which was signed on the 19th. Then a PMC, special PMC was called on the 20th to regularize the signing of the irrevocable.
Yeah. So are you then saying that you still then used 6.2 given that process?
With variations, absolutely. That's what I meant.
Yeah. Okay, no, I just wanted to be clearer. Advocate, yeah, you can go.
Chair, before my learned friend moves on to the next topic, there is a matter of concern that I must raise with the Commission. And I've asked him, it was not covered before this morning, and I'm sorry I'm coming in late. Dr. Matjila, and that is the evidence of Ms. Maury, that at the meeting of the 20th, She says in a statement, and she repeated that under oath, that there was a condition, and she called it a condition precedent, that no funds will flow unless AO agreed to a put option. And she referred to that put option as a condition precedent. Can you recall that?
I recall that statement, or I'm not sure if it was the recording. You know, it's been a while. I remember something to that effect.
She says under oath in her statement, I am certain that the Commission would pick up that, for example, the condition relating to the put option was a condition precedent.
Yeah.
It was specifically resolved that should AO not agree to conclude a put option, the funds would not flow. My problem with on the evidence and the processes followed, there was already a revocable offer signed by you. There's no room in that scenario to put in another condition precedent, the put option. That's what I'm asking you.
Commissioner, I think we've explained that IPOs, you can't put restrictions unless the PLS is changed for the benefit of everyone else. And we explained that this put option wouldn't be issued by IO for that matter, because of reasons that we've given. And we said this would be an undertaking that will negotiate with the promoter of the investment, which is AEI, to see if they cannot provide a put option. That would be negotiated. And there was no guarantee that there would be a put option issued within 2 days before the listing.
The bottom line is the funds in fact flowed without AEI agreeing to the put option.
Eventually, absolutely, because that meeting that day was about disbursement, was about signing off of a disbursement following the signing of the subscription agreement. Yeah.
Are you happy with the statement or comment that the CFO's consent or agreement was not obtained before you signed the subscription share certificate? And in terms of 6.2, she was supposed to have agreed.
Commissioner, repeat again. It's I can't hear properly.
Do you agree that the CFO in terms of 6.2 should have agreed for you to sign that subscription form at the time that you signed it?
No, not necessarily. The practice is not that. She agreed in the manner as contemplated. All the agreements are done in a PMC environment. As I said, the different teams gives the committee their recommendation, and based on that, an agreement is taken in that meeting. So insofar as IO is concerned, we couldn't get a meeting. That's why we needed ratification post the signing off of the irrevocable undertaking.
Yes, so just in terms of the option, the put option, sort of if it happens after the listing and the share price goes down before you sign it and all that, what happens? Because the PIC is exposed to risk then.
Look, I think it's a slight misunderstanding in terms of what is it that we are investing in. Commissioner, as I've explained, this is an investment holding company. The cash is going to be deployed into the future to chase certain opportunities. And this cash has got to be applied in a particular way. And one of the conditions that we put forward was that anything about 10% of the market cap must be approved by shareholders, which means shareholders have control over big ticket items, anything above 430 million, then will have to be approved by the shareholders. But on top of that, the 29% gives us leverage, which is something that obviously the PIC has to take advantage of and improve governance at IO so that they are closer to how the cash is deployed going forward, So if you look at the balance sheet, the money is there. It has to be quickly safeguarded for its purpose. And that will require an intervention, governance intervention from the PIC.
Yes, are you saying that maybe because there was a cash underpin in the holding company, that the share price is not very critical on a short-term basis? Am I hearing that, or
yeah,
you're saying something different?
If PIC's intention is a long-term investor to create a portfolio, to invest in a company that's going to create a portfolio in the ICT sector, and there's a pipeline that needs to be executed over time, the job of the PIC is to make sure that that money is channeled in the right way in building the portfolio. It's not misused for any other purpose other than creating this portfolio of investments, which is different from investing in a company, in a mining company, for example, that's going to use it for drilling another shaft or whatever it is. So that one is goes into the company directly. This one is about creating a portfolio of investment over time. And if you look at the other specs, you look at long for life, you look at Gaia infrastructure, you name them. Most of them trade below their intrinsic values, although the cash is still there. I'm not sure whether it's the market being impatient in terms of the rate at which these companies put together their portfolios. I'm not sure, but the trends is almost the same. But for a long-term investor, you know that the cash is still sitting there. It will chase the right opportunities to grow the portfolio over time or develop a nice portfolio over time.
Fair enough, but still there's a short-term risk that you need to cover. Would you say that ideally, you still have to do this before the listing?
I think
it's a good point you're making, but I'm just saying,
I think the problem here is that if you reference the share price versus intrinsic value and you are a short-term investor, then you'll worry about downside protection. But if you know that every time you read the balance sheet of the company or the statements of the company, you'll see that the cash is being deployed in the manner that it's supposed to be deployed, then you are comfortable because the share price then doesn't reflect much.
Yes.
In fact, if you had cash, you'd buy more cheap shares to bolster your position in the company, actually.
Yeah. And finally, do you know whether the intrinsic value of IO currently sort of reflect the share price, reflects the cash in the business?
I think intrinsic value is closer to 12 rands per share.
12 rands a share.
The last time I checked, it was trading at 8 rands a share.
Okay, so the price is lower than
dislocation.
So the price is trading at a discount to the, okay. All right. Okay, thank you. Thanks.
Just on a couple of things there, but in essence what you are saying is that there was no prior agreement as per the DOA in your consultation with Ms. More about the investment and signing the irrevocable. That you were relying on the PMC approval ratification process, and this would not be unusual, notwithstanding that the DOA requires prior agreement between you. You're saying it's not practical, and therefore we do it via the PMC. We don't go with what the DOA actually says.
So the usual practice is that we have PMC, if the PMC is a body that's supposed to approve. So the agreement between myself and Ms. More takes place as a collective as opposed to as individuals, because then there's a bigger risk that if we agree amongst ourselves, then we don't need PMC. We can simply do lots of transaction by agreeing. We saw that risk quite early on.
But you didn't change the DOA?
We didn't change the DOA. The DOA is 2015. We've, for some reason, battled to get it straightened up. And
Okay.
I'm sure.
The second question relates to the point you're making about intrinsic value, long-term investment. surely then the price you pay still matters. The price that you paid for IO at 43 Rand and its intrinsic value today. Notwithstanding a long-term investment, you could have made, to me the question, the share price does matter because that's the amount the PIC invested in a hypothetical, not once, 3 times, well, one you didn't invest, but it was part of the process, in the same company about what could be if these things happen. Now that's all very well and good, but then you don't pay top price. You don't pay as if it has happened. What I understand on the IO subscription payment was as if this was in place, rather than if it will come into place. I fully understand long-term investment. I fully understand what you want to look at, saying down the line we could get that kind of return. But from where you are now, it's going to be a very long time before you get back to the kind of investment that has been made. As you say, you could have done it at a much cheaper price. So the question I'm asking here is, are you comfortable that your decision to invest on the information that is available today, that you paid appropriately for that future return? Because it may or may not happen. So far the money's sitting there, and you paid 43 Rand a share for something that was a hypothetical. The same as independent media, 880 million Rand still owed, the investment was based on what independent media planned to do, but has not materialized over the 7 or so years since the investment.
I think it's a slightly unfair question because now you're looking in a rear mirror. The question is, if we do Anglo now on the views that we had at the time, right, and we make 20 billion out of it, at least it shows that we can do things. And if you look at our portfolio and you see that how well we've outperformed the benchmarks, it tells you that the formula that you're using is working. It doesn't mean it will work on everything that we invest in. There will be some that we get wrong. As long as those that we get right far outpace those that we get wrong. That is how an investment manager or portfolio manager is measured. It's not on just a single transaction, and therefore it means that you are a bad manager. It's all about portfolio diversification, and most importantly, we do take risk. We have to take risk. Some risk will pay off, some will not pay off. As long as those that pay off far better than those that don't pay. That is the principle of portfolio management.
I understand that, and you have told us repeatedly on that.
And by the way, it's like how many instruments that we're talking about. In the listed space, it's almost 180 or so shares that we deal with.
Yes, but this is one investment in a company where you've made 4 investments with the same company on the same basis of hypothetical. That's why it is a question, Dr. Matjila. It's not all the arguments that you're putting forward about risk. We understand that. Some things work, some things don't. It is a question of the price paid, the due diligence, and the decision-making process around this based on the 3rd entity or the 4th entity with that company, excluding the Sagarmatha makes it 3, based on hypothetical outcomes. That if this happens, that will occur. And paying a price that is questionable given what has actually happened. It's not with rear view mirror, it's a question of what due diligence was done, and as you've indicated, that was done on the basis of the pre-listing. You did a due diligence on the pre-listing, not on the company.
Commissioner, I can argue that all the analysis is hypothetical. When you do investment, you do projections, you do all kinds of things. You can't get it 100% and say, well, I'm investing in this one. I'm telling you, I see an IRR of 25% per annum, and you get it. You'll be the best sangoma under the sun if you can do that. Investments is about guessing. it's about risk management. Let me not start another gospel around investing or sermon on investing. I think I've done quite a bit. But I accept some of the comments, Commissioner.
Yes, and I think in many ways too, it depends on the level of blue sky that you're putting in that share too. I mean, like investments can go wrong, we know that. But I think too, it's the blue sky part. If it's huge, then it becomes a problem, isn't it?
No, I agree with you. And I guess you may think about what is the escape valve that you can use under the circumstances. You know.
Yeah.
So I was saying there is an opportunity to fix this.
Yeah.
Actually, because now that we know there are certain things that have not been delivered.
Yeah.
What are the options available? Because the cash is there, it has to be secured for the purposes that it was intended for in the beginning. And so that requires a governance intervention and certain things being done to salvage the cash and probably even the company and put it in a much better platform and branding as well as many others through cleaning up governance and cajoling BT to come back and become a partner and grow this thing as was originally intended.
Yes, so you said, look, there's too much risk in IO, but if we can get a put option, then that risk is sort of mitigated somewhat.
So you can
is that what you're saying?
So you can get a put option. If you can't get it, because it's an investment holding company, there is an embedded put option there. Because there is cash that is sitting there to be invested. And how do you then get control of that so it's used for the purpose that it's supposed to?
Yeah.
That is the embedded put option that I'm talking about.
Yes, like in the mine, sort of as you say, you put in a platinum mine and the price of platinum collapses.
Gone. The money is gone.
Yeah.
Here we still have a fair amount of control.
All right.
You can control the destiny of the company.
Yes. Okay. No, thanks. Yeah. Next one, just to belabor the 6.2 DOA since we were taken there. Just in terms of the practice then, it means that these DOAs don't work, especially Section 6 then. They're not, you are doing the PMCs where you are not supposed to do them and all that. So it means that this section is not necessarily being applied, and probably the way you are doing it is maybe the better way, but this section says different things. So what must happen then? Do you change the DOAs or what?
I think the board was happy. They gave us this and say, go and implement this. And so then you set up processes to do this, and you look for the best processes that can give effect to this. We found the process that we designed through the standard operating procedures of pre-due diligence, due diligence, and this and that, and final approval depending on the body that has authority to do so, to work a lot better because it allows everyone to get involved in the transaction. Rather than, if you look at it at face value here, and you want to apply it this way, it's not appropriate at all. So we are happy with how the standard operating procedures have augmented or have assisted in giving effect to the delegation of authority in a much better and successful way if performance of the PIC has anything to go by.
Yeah, we can continue. Advocate.
Mr. Commissioner, I see that we are about 10 minutes past 1. Is it a convenient time to take a lunch adjournment?
Yes, we'll take the lunch break until 2 o'clock.
Mr. Mohapi. How are you, sir?
Stop commenting your client giving evidence.
No, you know what? I'm trying to get the show moving along so that we can all get out of here today, which is why speaking to you. Have you got a lot longer to go?
Before 6. A lot of my feedback is covered with questions.
All right. Okay, so how long do you estimate?
Maybe less than an hour.
Less than an hour, 2 o'clock. It's 3 o'clock, and it's 56 tonight.
Why?
Well, because we're still going to go through recommendations after this.
Yeah,
And
now
there'll
we
be
fast.
some questions on recommendations.
Just got to
I mean, I don't mind working a little later, but we must finish today.
I'm
Okay. Thanks, boss.
Let's aim to get out of here before 6. Aim for before 6. Let's get out of here before 6. Being too ambitious.
has been done, so disbursement has to take place, so money has to be ready to pay. And we were quite clear that we don't keep stash of cash somewhere to pay for acquisitions. We have to liquidate certain liquid assets or near liquid assets to be able to do that. So Hanewe asking for guidance, I don't think it's a sin for her to ask for guidance on how to handle matters, especially when his next superior is not available. And so guiding, I don't think it's a sin for her to have, or it's a sin for me to have guided her on what needs to be done. And I don't take it as intervention at all.
So would you say that also for the fact that you wrote a letter on the 20th of December, which Mr. Nodwele came and picked up at your house to take to the JSE? Would you say that's also normal?
They requested the letter. The letter was sent to the JSE and not Mr. Nodwele. They just needed a copy.
Well,
and so I provided with a copy. I don't think it was anything unusual about them asking for a copy.
Mr. Nodwele says the following in his evidence. Paragraph 16, page 9 of his statement. I'll read in relevant part. Khalid Abdullah called me on 20 December 2017, one day before the listing. He informed me that he had a top secret and important task for me to handle. It had been apparent through facts that were now being made public via this commission and the media that the PIC had no funds to invest at the AO listing. And this is the important part. I was then requested to urgently drive to Dr. Dan Matjila's house to go and collect a letter for the JSE, effectively advising them that the PIC was fully committed to the transaction, but had to liquidate certain assets before the full capital commitment could be made in AU. And what's remarkable about this is we in our investigations, had it not been for interactions with the JSC, couldn't have found this letter in the records of the PIC, and one would have thought that if it's normal, you would have reposited this letter with the PIC.
I don't understand. This letter was for the JSC to ask them to give us time to deal with liquidity issues.
Indeed, but it's a letter written on the PIC's letterhead.
Yes.
You write it from your house, and
I've never written a letter from my house, Commissioner. This letter was written at the PIC and dispatched to the JSC, and they requested a copy of, Nodwele requested a copy of that, if my memory served me well.
Why was it a top secret thing?
I don't know why he called it top secret. I was not involved in the discussion at IO, quite frankly.
And how do you explain that it wasn't in the PIC's repository of documents concerning this deal?
I don't understand why, because that letter was done at the PIC, if my memory served me well.
What normally happens with letters that you write? You write longhand or dictate?
These are very short letters that says we don't have liquidity, we committed to the transaction, and therefore we've signed an irrevocable, we are committed to the transaction. In other words, the only challenge is liquidity. That's what it was designed to do.
Is it a typed letter? I'm asking you, Dr. Matjila, can you remember whether it was typed?
I think it was a typed letter, I think. It's just that I don't have a copy of it, but it will be on PIC letterhead because it's an official document that I've signed.
And who would have typed it? Your assistant?
I imagine it should be here. Or sometimes we do have draft copies that are sent to us, and then we just tweak them to PIC environment and then we send them off.
Then once again, this is an important letter because AU had committed itself to raising 4.3 billion, and if a company has committed to raising that for its IPO, it can't list unless it's got support. So I'm just pointing to the fact that this is yet another thing that you've done to assist the deal.
Commissioner, we have signed an irrevocable to make the deal happen, and we have to pay. And so if there's no liquidity, there are ways of remedying that, and this is just a process of remedying that. To say that we don't have full cash, we have 500 first to meet the first requirement of a listing. which then the balance will be done at a later stage. That's nothing unusual about that, quite frankly.
And there's, would you say nothing unusual also with you insisting with the deal team that the timeframes could not be moved? As Mr. Siani testified, paragraphs 36 to 38, and Mr. Malebadzi, 35.1 of his statement.
The listing date was set in the PLS. I'm not sure how I would have abandoned the transaction at that point.
Yeah, just, the question has got to be asked, Dr. Matjila, that there's so many things which have pointed to you intervening as the CEO in this deal. You've signed the irrevocable subscription form without PMC prior approval, nor with consulting with the CFO, sorry. You've said to the deal team and the rest of the team, you will get ratification. So that was a matter of comfort for them to proceed. You've intervened in telling teams which assets to liquidate. You've written letters to the JSC which had to be collected from your house. It's just too much. That seems to suggest that you are doing too much as a CEO in this deal.
I don't have a comment. That's my job. I get paid to do my job with the CEO.
Are there other deals where you've done the same?
I can't recall. I mean, there's lots of deals. In 15 years, we do all sorts of things, you know, so I can't recall, you know.
Mr. Commissioner, those are my questions.
Just a quick question on the selling of the shares to create liquidity. And I think you said it's been done in 2 stages and all that. Was there any pressure to sell some fixed income stocks or whatever, money markets or some shares, you know, to create that liquidity? So was there pressure in terms of there could be a fire sale to sell instruments to create the 4.3 billion raise, just to check if there was that kind of a pressure?
There wasn't any pressure because there was a standing selling order on Anglo, which is very liquid, and therefore it will be the best to liquidate, to make cash available to honor the transaction. But Hanewe, in her wisdom, decided to optimize the selling by not only selling Anglo, but selling others to optimize the total amount that we are raising for the consideration of the deal. And I said I commended her for that because that shows proactivity, you know. That's typical of a PIC employee, that they will go miles to find the best solution for the clients.
Yeah. And then, just in terms of the letter that had to be fetched from your home, was that because you sort of had to sign it, or it was a signed letter and you asked them to fetch it from the home? I just want to find out.
The letter was signed. They needed a copy for themselves. So I said, well, it's fine. They can come and collect a copy from my house.
Yeah. Mm. Yeah. Okay. All right. And there was a copy of the PIC too?
That's what I expect, because that letter was done on PIC letterhead, and therefore it would have been a PIC, you know.
Yeah. And who called you to get that letter? Was it?
I can't recall who it was. Yeah.
Okay.
I can't recall who it was.
All right. Okay. Thank you.
Thanks, Dr. Matjila. Some of these questions that I have you've already addressed, and I'll try to separate out the ones that you have addressed and the new ones. But let me, and I'm just going to start with the IO transaction and then perhaps move to some others. Okay. Just on IO, when we asked Ms. Moray about the 1 billion rand for the 30% stake in BT, and that it was 1 billion, and the evidence by Mr. Nodwela was that this was an illustrative number by the person that had asked to look at it. Did you query the 1 billion as a related party transaction and the valuation thereof? Or did you take it as given?
I think that's the reason why we didn't transact immediately on BT, because we needed to satisfy ourselves that the price is the right price. And the team insisted that they see so they can do the calculation. The billion was approved, it was in the PLS, but they said this can be done at a later stage if we have to.
But that would have been paid for by the PIC purchase of the shares. That's what the 1 billion was earmarked for, was to pay over to AEI, which owned the BT shares.
At the right price.
At 1 billion.
There's an indicative price of 1 billion.
Right.
But the team felt that they need to satisfy themselves that 1 billion is a number, because if we can get it cheaper, then it means the 4.3 billion gets, you know.
So was that work done?
That was the process that when I left was being debated. The BT transaction was not done as far as I can remember, because we were still trying to get the right price.
Okay, but there was no BT agreement as far back as August 2018 to sell those shares, I mean to be part of the transaction at all, and that the shares could be sold in that way. Were you not aware of that?
I think that one we got to know later on, if I remember well.
And then the question of the various valuations and the bumping up the various valuations, according to Malik Sally, of an original valuation of 2.3 billion to the final valuation where you bought the 4.3 billion rands worth of shares at 13 billion, about that. How are you, at what point did you become aware of the price manipulation by Dr. Survey?
Yeah, I learned it in this commission when Malik Salib
gave
his evidence at this commission. And it was with the shock, because he was very central in putting together the PLS, the basis of which we've used as an investment, for an investment case.
And then the question in relation to that, because that part of that investment, the quantification or the value was with, and you have addressed this before, but in the same IO question, it was a profit before tax to grow it over 2,500, about 2,500% in 2018 by 25 times, and a further 44% in 2019. Which would show that profits in 2019 would be 36 times higher than in 2017, or 3,628% growth. As a financial man and a person who's dealt with many of these things, how credible were those kind of numbers that you took them as real?
I think first I'm advised by the team, as I said earlier, but secondly, even Kevin Hardy, who appeared before this commission, said that they were confident that they will reach those numbers once the BT moves on to the IO platform.
But there was no BT.
But there was no BT, of course.
Right.
But the cash is still there.
Now the cash, the question, let's not go to where the cash is sitting at this point in time, because the money has been paid and raised, and whether it's there or not, some has been spent, some may be invested, interest earned. Obviously, of the interest earned, there's very small return for the PIC.
I don't want us to scare the public into thinking that the money is gone.
No, you've got a 29% stake in IO, which is now at 8 or 9 rand a share when you paid 43.
The NAV is 13 bucks. 13 rand, sorry, Commissioner.
Okay.
I keep saying the bucks.
13 rand.
Yeah.
And we've dealt with some of the questions. The one issue for me there are two factors that I think are important. First would be the related party transactions, and one of the issues in your memorandum of agreement is that the PIC would act in terms of would ensure that all deals are done at arm's length, given the extent of related party transactions here and the different fees paid to the different related parties. How have you, and I mean fees earned and fees paid are something you have said throughout your testimony you don't pay much attention to. That's not an area that you look at. Don't you think that's a question of related party transactions and where the money is then deposited, and the question of having enormous fees paid to related parties?
It's a concern, I must admit, Commissioner.
Because in this particular instance, the fees paid to the various groups within Sekunjalo was over 70 million rand.
Understand so, yes. Yeah.
Were you not aware of any of that?
We got to know about it later on.
But is that not something when you're doing a deal, you look at who the advisors are, what funds are being paid? Is that not part of the agreements that you look at?
No, Commissioner.
So this can be...
I mean, if it was in the unlisted space, we would be looking at it differently. But because there is a document that gives all investors comfort that the checks and balances are in place, and therefore an investor can make an informed decision based on that information, the PLS, you know, that's unfortunately what we used in this instance.
Did you look at the investment of IO, given the cumulative issue that you had independent media which was still not servicing its debt of about 880 million, which I understand is still not being serviced, and yet you are going not just with IO, you are also looking at Sagarmatha parallel process?
I think I'm seeing a distinction between assisting or funding an investment. In other words, in this instance within NMSA, we have given them debt to buy into independent news media and a 25% exposure to the equity. And the total is about 1.3 billion. But insofar as I is concerned, we are a co-investor. In Sagarmatha, that we didn't do, we were going to be a co-investor, not funding Sekunjalo. But so that will be the distinction. And in Premier Fishing, we are an investor as well, alongside Sekunjalo and other investors.
And as you say that you are a co-investor, but the question of taking up the full subscription, Malik Sali at the time of the release of the PLS on the 13th of December, which was closing off on the 15th of December, said, I had not engaged with any other investors than the PIC and union members. And therefore the question would be that the full subscription was expected, and that relates also to Mr. Madavo querying the meeting on the 14th of November in Cape Town, where he asked why the PIC was taking the whole investment on offer. And Mr. Abdullah at that time said, we prefer the whole allocation to go to a single strategic investor. Given the increase from 20 to 29%, is the PIC simply a price taker in those circumstances? And had you discussed any of this, because there were repeated statements made by various parties about Dr. Survey and yourself meeting and discussing the PLS and discussing the transaction, had you had any discussions about IO with anyone from Sekunjalo, whether it was Dr. Survey or anyone else? And did Mr. Madavo raise with you his concern about taking the whole subscription?
I think I've explained in the beginning that Mr. Madavo was leading the transaction. And from what I can see and what we have, information that we have, submissions that we got from the team, is that they were comfortable with the 29% eventually. So discussions with Mr. Survey, I did have discussions probably earlier on around how they're going to resolve the INMSA issue, as payment was due on the 18th, I think, on the 31st of August 2018. and various discussions earlier on around how they're going to do it, and introduction of Sagamat and many other things. So we had those discussions, but not necessarily the process around IO per se, because that was handled by the teams directly, the transaction teams directly.
The question of the investment committee raising a number of issues in April around more information about the timing of the IO investment and whether it was in line with the DOA, whether the PIC should be cautious about empowering the same individuals a number of times, and the counterparty risks to be included to avoid reputational risk, that it must avoid a situation of ratification, and concerns about the put option, which was for 22 Rand for 3 months, which on expiry fell to 3 Rand. And although that was only signed in September as a post-condition requirement, the questions raised by the investment committee, how did you deal with that?
I can't remember how those were dealt with, Commissioner. It was quite a number of things, but I remember quite a number of them were being dealt with by the team as far as possible.
Sorry? Go on, sure.
Just as a follow-up question there, would you suggest that there should be limit in terms of how much you spend per sponsor, or per sponsor person, or per sponsor company? And if so, how would that work? It's not an easy thing, this, you know.
I think it's not an easy thing. Probably there are better checks and balances that can be put in place, but if someone has a great idea, that will make a difference to the portfolio and therefore the economy. We can't say to them, we don't like your idea, it should have come with someone else. You know, we still have to at least entertain the idea and find ways of dealing with it. I mean, in this instance here, if you are an investor, co-investing alongside someone is different from when you are funding them. And therefore you have, you know, they have an obligation towards you. The obligations in this, it's about the company delivering on value. And that requires an appropriate governance which will act on behalf of all the shareholders. And as I said earlier, with 29%, the PIC is able to influence that strategic direction and therefore influence the nature of governance that should be taking place in the company so that it's able to drive wealth. So I think if you have the right governance in place to ensure that your risks are proper, or you are in control of the risks, you are not giving the risk to whoever you are sponsoring, because all you want is the idea that they have, and the execution of that be left to the right structure to deliver on. Because otherwise you'll end up rejecting good ideas that can make a difference to the portfolio, and do the same thing of just funding exchange of shares between BEs, which is totally undesirable in my view.
Yes, because I mean, people can get, do transactions and maybe get better and better, and they are well networked, and they are well networked, and they can bring great transactions. And how do you stop them? I'm just trying to think, how do you say you have done 3 or 4 deals, that's it, and you find they bring a blockbuster idea? I mean, it's a very difficult issue to.
For me, it all boils down to governance or risk management. How, if you are with this partner that has come back many times, what are the risks, issues, and how do you make sure that you are in control of managing those risks? I mean, if we were to use IO as an example, and most importantly, what we can learn out of this opportunity is that it's time now to intervene properly in driving the right governance, and therefore taking control of the risk and building the portfolio going forward,
So it's not the person per se, it's the ideas and the company.
The execution of that idea. That's critical.
Okay. Yeah, thanks on that one. Yeah.
Perhaps just staying with that, did you ensure that, given that, because it isn't just about IO or Sekunjalo, there's a range of companies in which there's multiple investments, 3, 4. What is the way you've assessed cumulative risk? Because what seems to have come before us in the process is each application is dealt with on its own. We look at this transaction and we see it for what it's worth, it's good or it's bad. Individually they can be good. What is the cumulative exposure? What is the cumulative risk? What is the measures taken to ensure that that is dealt with? How have you dealt with that? Because that is unclear to me.
I think that it's diversification at work here. That if they are in different sectors, different strategies, and probably, as I said, the challenge would be who's executing the strategies. You know, you are co-investing as opposed to financing someone, but you rely on the jockey to drive wealth. Now, if they have failed in newspapers, does it mean they will fail in IT? And what are the chances? What are the risk management tools that can be used to make sure that they succeed going forward? I mean, what I've heard here from the different testimonies, from Malik Sali to Nodwele, as well as Hadi and Hamildin, were governance issues mainly.
Absolutely.
Which I think can be dealt with immediately. And there are ways of dealing with that to put the company back on track.
But isn't there a governance issue in the PIC itself about the cumulative risk? Because what I'm asking you is not what's happened as you've indicated with IO. I'm asking as a matter of principle from the PIC when you're taking an investment decision in terms of your processes. When you look at the cumulative risk, when you look at the cumulative exposure, even if you've got diversification, how do you assess that this is deal number 5 with the same group? Does that take us beyond a comfortable level? Do we wait a while, even if it sounds like a good investment, to give us some track record to see how the investments are progressing? That cumulative risk approach has not come through in anyone's testimony for me. And therefore, you as an investment, formerly CIO, now CEO, what weight do you place on cumulative investment risk?
Yeah, I think that's what I'm trying to explain here, that are we dealing with cumulative risk as in the promoter? Because here we are dealing with co-investment and the promoter is sitting in different companies in which we are invested. We are just an investor. Now the biggest risk is what sort of governance structures are put around this to make sure that things that have happened now don't happen again. Related party transactions, interference, and all of those things don't happen. So that these companies, each one of them, are managed properly. Because if this is successful and these companies becomes huge in the JSC, and we've seen many other companies that have been successful that have this kind of structures, you know, Remgro and them, they've done quite well, you know. What sort of governance structures would you like to have? Because if they get bigger in the JSC, there will come a time where the PIC has no choice but to have an exposure because of other risk parameters that need to be taken into account. PIC is taking a strategic position with the view of slowly exiting, reducing its exposure to allow other investors, but in that process, hopefully reaping rewards out of that, you know, to a point where they become just an institutional investor in line with the mandate. This is what strategic investments are about. So for me, the diversification around across different sectors is important. That's the first step that you deal with in terms of risk exposure. Secondly, a co-investor as opposed to a funder. Those two are different. We are just a co-investor. The biggest risk is an appropriate governance structure across that allows these companies to run efficiently, well-governed, and therefore creating wealth as they're supposed to. So in this instance, I think governance becomes very important. You can look at cumulative risk. Of course, it's important to quantify and get to a point where you say, we can't go beyond this. But just not doing it because it's the same person, although they have a good idea, is not great. You'd rather be focusing on how you manage the risk of ensuring that if it's the same person, they don't, or the company has the right structures to ensure that this investment becomes successful in the long term.
Taking that on board, and as you say, you are in this particular instance of IO, a co-investor, how, and obviously this may well have come out post your leaving the PIC, but given them what I would call misstatements in the annual financial statements around what profit there is and where the money and income and investment income or interest income and so on, as I've pointed out earlier, how would you as a co-investor, how is that, obviously you can't answer now for what steps the PIC is taking, but that money is sitting there, as you say, the funds are there, they're not necessarily being used the way they were stipulated to be used, and that there is misstatement subsequent to this in the annual financial statements that appear, or certainly appear to be misstatements of fact about where the earnings have come from, as I illustrated earlier from some of the quotes. How would you perceive that from where you're sitting if you were the CEO right now? What steps would you take?
Commissioner, first there's a regulator who has to step in.
No, but you're a co-investor. You're no longer simply an investor. You're a partner in that. Therefore, you've got 29% stake, and this is in your name as well.
I'm getting there, Commissioner. Yeah. 29%, I think the Companies Act does allow any shareholder that's about 10% to call an extraordinary general meeting and propose certain resolutions to remedy whatever problem there is.
Would you recommend that?
I would have probably moved on that a long time ago to remedy the situation as quickly as possible.
Sure.
Just to follow up on the question of risk to the sponsor and all that. And the first portion you mentioned is, the various pods could work pretty well in terms of good ideas. Wouldn't you want also a culture of performance in the sense that the sponsor, the promoter should have shown some great performance, some great track record before maybe you go to the second, third, fourth transaction? As you know, like a person like Brian Joffe who could acquire companies, he developed a serious track record at Bidvest, and people then began to back him up. Don't you think maybe the second part should be track record before you go to the next transaction?
Yeah, I think it's a difficult question when track record. One thing, the reality is that the first transaction was in a tough space of media, and it hasn't worked. Now the proposal around technology is one of the most appealing, and the 29% was being taken specifically to make sure that the risk of the PIC will be safeguarded through interventions. Through that, 29% gives you a certain responsibility.
Sure. No, I'm just talking broadly. Yeah, I'm talking broadly. I'm not even talking about, say, that transaction and all that. I'm just talking broadly. Don't you think there could be another leg just to think about when
there's a certain race that doesn't have much track record and is still struggling up to now, so there will be instances where you will have to take risks with them, alongside them, as long as you are part and parcel of managing that risk through representation, adequate representation on the structures to make sure that things are done properly, and certain conditions including, I think we've spoken about, policy on what you call conflict of interest policy that's supposed to kick in, and so all of those things put into place to ensure that good governance take place at the companies.
No, I get you. I get you, because then maybe you could be excluding quite a number of people.
The biggest population in the country here hasn't got much track record, and therefore we have to take.
As long as you can manage the risk and the corporate governance and the other issues, is that
that's what the 29% or significant shareholder should be giving you to as the PIC to drive that.
But then, what if someone has got 20-year track record, they've been there, what about that? 20, 30 years?
And they've not done well?
Yeah.
It's a hopeless case.
That could happen.
That's true. I mean, unless they were, maybe you have to look at the advisors, they were badly advised or something like that.
Yeah.
But, yeah, we can't just not allow ideas, spend some money on good ideas.
Okay, no, that's fine.
We have to manage the risk of being with multiple partners, in other words.
Okay, thank you. Yeah, that's fine.
But of course, I'm not saying the quantum must not be quantified. There has to be limits. I agree.
Dr. Matjila, were you aware that in terms of the build-up for the share allocation, Mr. Hardy stated that the IO sends in December, on the 18th of December 2017, said that share allocation had been oversubscribed by 1 billion rand. And Hardy stated he was surprised at this and subsequently learned that the entities were all related parties, namely Three Laws Capital, Capital One Investments, Selwyn Lewis and Miramel Investments, quote, who had never intended to take up their subscription and had been used to create the impression that there was market demand. Were you aware of that? Were you aware
I wasn't
of
aware.
those things?
Yeah, Commissioner, wasn't aware. And I mean, if Hardy, who was within the company at that time, wasn't aware, then it's a big problem.
Would you say that, looking at it in hindsight, obviously, that this would have been something of great concern about governance?
Yes, it is, certainly.
Dr. Manning raised the question in relation to IO, saying, and we know that it went to PMC, and we've had the whole discussion about PMC, but she raised her concerns about concentration risk and confirmed that she wasn't talking only about IO, she was talking transactions such as IO were not referred to the investment committee or the board as they fell within the delegation of authority for the PMC to approve. She was raising concerns that this was perhaps not the best way to have dealt with them, because then your investment decisions were taken at a different level. She also raised a concern about the letter from the GEPF that expressed serious concerns about the decisions being taken by the PIC. What are your views of that?
Well, the delegation of authority, obviously, we get from the board.
Sure.
So we had the delegation of authority, and if there was discomfort, and I believe they raised those discomfort, and we were in the process of changing the delegation of authority, to the satisfaction of the investment committee. I don't know how far that process has gone. The GPF picked up all the noise in the media, and I think we responded to them. I think eventually we had responded to them, explaining ourselves what has happened in this transaction.
The GPF concerns were not only about this transaction. When Dr. Satola was here, it was also a question that he raised other concerns about lack of meetings, lack of engagement, difficulties of meetings. Are you comfortable that the relationship and the working relationship between the GPF and the PIC was at the level it should be, given the governance issues that you've raised?
Commissioner, I think at management level, we were meeting quite a lot. I think there was a misunderstanding when he spoke about meetings that have been cancelled. I was talking about the investment committee and the board at that level. But at management level, there's been a lot of interaction. Even in meetings where I'm unable to attend, there will be someone representing me, and vice versa. So at that level, I thought the relationship was okay. It's only at the board where there was not much interaction as we had planned. We had planned meetings between IC and IC, Social Ethics Committee to Social Ethics Committee, ACT to ACT, all those critical committees of the board to have interaction. We had, but not with very little success.
That's an area that will need to be looked at as well. But one of the issues that have come through in many of the testimonies, particularly from people working within the PIC, was the challenge of time pressures. Now, there's always deadlines and there's always time pressures. That goes without saying, but the question that has surfaced, in fact, has been using time pressure as a reason to bypass agreed processes, rush investment decisions, including the use of round-robin resolutions. Do you think there's validity to that question, or do you think that time pressures do not play a role in bypassing the processes?
I think time pressures are there, and probably it's because of the size of the responsibility that the PIC has to deal with. This is 2 trillion that the PIC is dealing with. Transaction volume is quite huge. It's a big participant on the JSC, and the PIC is trying to do listed, unlisted investment, including property, under one roof, controlled by a small group of people, including the structure at the board level. And you have board, IC, and FIPS, and then you have PMC dealing with 2 trillion. Listed investment that are less complex and unlisted investment that are very complex, including property. It's the nature of, or the structure, that is probably posing a challenge for the PIC. It needs some kind of rejigging. Maybe we'll talk about it when I make my recommendations, which I believe can work, because once you break PIC into pieces that operate independently, you have lesser pressure that you are looking at listed investment tomorrow you are looking at unlisted investment, you're looking at property and many other things, being done by the same group, posing other risks, of course. I can
come
only
to recommendations later.
Yeah, I can attribute the time pressure to the volume of work that has to go through in the organization.
If you had to, okay, we'll come back to that at another point. I know we're having a discussion about, I'm moving off IO now, if I can. I just to have one question in relation to Lancaster. Okay?
I will try.
I'm sure you can try. You should be able to try.
I thought we were dealing with IO today and finishing off, but it's okay.
I thought finishing off with you today was what I was told, so it's all the questions that we may have that are outstanding as far as I was aware.
As long as those questions
if there's any question that you're not sure of or that you would like time about, there's absolutely no problem. You can always look at it and we can give it to you in writing, and you can come back to them in affidavit form if you want to do that. That's not a problem.
I will try, Commissioner. Yes.
I have one question on Lancaster. The L101, if I understand it, was funded its STAR by the new bank finance, which was against the put option that was provided by another bank, and that was for 6.2 billion, correct?
Yes, Commissioner.
In addition, because my understanding that was the total investment, but in looking through the documents, there's a 280 million rand general corporate purposes. General corporate purposes. It's given to various aspects of the deal, the question of meeting your targets that you committed to with Steinhoff as Lancaster. There was other payments for tax and other things. It amounted to 280 million, which was then funded. Where did the additional money come from? Because then in essence Lancaster got 6.5 billion, not 6.2 billion. Where did this other money come from and who authorized it? And obviously we'll also address it to Lancaster, but it came from the PIC, so where was it in relation to the totals?
I think, Commissioner, the PIC transaction team will be better placed to answer that.
You're not aware of it?
Yeah, because the total approval would have covered all the costs related to the transaction.
To the best of my knowledge, that's what I understood it to be in the initial and in looking at the documents, but there seems to be this additional 280 million that came from somewhere. So perhaps we will need to follow that up and include it with Lancaster itself. But if you don't know, that's fine. We just know that there's that amount of money missing. Or we're not sure where it came from, but it was allocated into Lancaster. I want to move on to Erin. Okay. On Erin, and I think you had dealt with this when I wasn't here that day. So it may be covering some ground that you already dealt with. But I was interested in that Mr. Ndadze stated that the initial investment in Erin Energy was for $250 million, but the value of the asset declined to $150 million, and the PIC, as a significant shareholder, had to provide a guarantee that could be used to raise other funds. But the guarantee, he said the guarantee was not disclosed. What does he mean by saying that the guarantee was not disclosed? He also stated that from the outset, the issue was one of solvency and that there was no due diligence from risk. And he raised questions as to who actually owned the oil fields or were they leased to Erin. Erin's debt at the time of this investment stood at $405 million. So there was a debt of $405 million, an investment of $250, a guarantee of a further $100 million, the value declining. That's Mr. Ndadze. Mr. Chikudo, who is I'm going through the issues around Erin so that you get the picture that's of concern to me. Mr. Chikudo is an engineer in the energy sector and an energy specialist. In his testimony, he stated that he had first come across the Erin deal when he worked at Standard Bank in 2013 and rejected it as they thought the production forecasts were very optimistic. They had concerns about capital requirements and were skeptical about Erin's ability to fund and develop the ostensible reserves. The transaction at that time from the PIC was being handled by Mr. Modavo and Mr. Nesane. In 2014, Erin approached the PIC, which invested $270 million to obtain a 29% stake, and in 2016 provided a further $100 million guarantee, that's the same guarantee via the Mauritius Commercial Bank. He stated that oil is a very specialized field and that the PIC needed highly qualified people to do the due diligence, but he did not know, although he was a PIC employee, he did not know who had worked on this in the PIC. In April 2017, Mr. Chikudo was asked to conduct a review of the investment case prior to the drilling of Oyo 9 and Oyo 10 wells, and he submitted a report which stated, among other things, and this is then from Mr. Chikudo's report. Erin was insolvent and required capital injections to remain a going concern. Even if Oyo 9 delivered the production as it projected, it would still require a capital injection before 2021 of a further $470 million US. Management relied on the forbearance of trade creditors to forgive Erin's $405 million outstanding debt, which if not forthcoming would require this further amount of support. The reservoir management reduced confidence about production, and there were rapid decline rates under the management of Erin, of ENI. The report concluded that the PIC was unlikely to earn a meaningful return and recommended that the PIC not go ahead with the provision of the guarantee and to exit Erin equity investment. He He sent this report to Mr. Modavo, Mr. Dolamo, and Ms. Solomons, and followed up in May 2017, but received no feedback. But he started to receive invoices which confirmed to him that the PIC had proceeded to provide the $100 million guarantee. The question is, what was disclosed at the time of investing, and what did the due diligence reveal? What were the issues about the investment case that were taken to the investment committee? Because they only showed financial data to the year end of 2012, December 2012. The essence of it was that the guarantee meant that the PIC took on the credit risk and the risk of default. Does this mean it was actually a loan? But a loan to a technically insolvent company is surely an equity investment. Did this not need to then increase the 29% stake in Erin? Were these guarantees and such investments within the GEPF mandate? And were the real risks of this investment, knowing those circumstances, adequately discussed? The Ndadza risk report of the 1st of June 2016, reviewed and recommended by Modavo, and there's something wrong with the dates there or whatever, because Modavo's recommendations on review is a month earlier, were rated medium due to expected increase in production, despite technical insolvency. How would you have a medium risk if you're technically insolvent? I'm not very sure. And the risk of insolvency is rated low, although you were technically insolvent, based on creditors' continuing forbearance of the debt of $405 million and the expectation of a future equity rise. But in 2 years, it was insolvent. The PIC valuation at the time was $4.10 per share, but the current price was $2.08. Why was this seen by the PIC as an opportunity rather than a warning that the actual price was way below your valuation? And was an enhanced due diligence done on the PIPs that were involved? There were Mr. Busari and Mr. Laval, and Mr. Laval has come up in a number of other circumstances as well. And if there was an enhanced due diligence, what were the findings thereof? The total fees per the utilization request appeared to be $8 million, but the actual disbursement was between 63 and 66 million US dollars. So 12% of the funds went on structuring and deal fees. Was this raised at the board or by the PIC? This was signed off by yourself, but there seems to be no invoices for about 34% of those deals, about $24 million, while $34 million was used between 28th of June and 18th of August, 48%. What governance was in place to see how that was documented and that it was met? And the outcome is really what concerns. The outcome was no successful drilling. In April 2018, Erin filed for bankruptcy. The Nigerian government has taken over the license. The ownership dispute was decided in the courts in favor of ENI and AGIP. So what's happened to the PIC investment and the 29% stake in Erin? And what happened to the existing assets? Have you looked, and during your time, looked at this Erin investment with the outcome and the numbers involved? Because obviously here we're talking dollars.
I think, Commissioner, it's very important to understand how the PIC works. There is a technical team, I think I explained this before, that advise us on technical work. There is an ESG, there is legal and others, whose recommendation goes to a particular committee, whether it starts with PMC, of course, and PMC then recommends it to the appropriate committee. Now, I'm sure if you look at the approval process around this, will have the approving committee would have been the investment committee based on the recommendation of the technical team that would have done the work. Of course, I'm a member of the investment committee, but in this instance, I don't want to be singled out as if I'm the one who did the transaction on my own. This is an investment committee decision to invest in Erin Energy. and to provide a guarantee in Erin Energy. Most of the issues that were raised, PIC was not aware of. I think we explained at the last sitting of this commission that there are lots of things that were hidden away from us, from the other side. You know, although we sat on the board, we had representation of the board, most of the issues that we are now covering, or they are now come to the public domain, we were not aware of, including the fact that Allied Energy has not paid in full the assets that they bought from Ajib, hence the court case that Ajib won in Nigeria. That affected our investment in Erin Energy, which was entitled to the barrels that come out. At the same time, once we concluded this transaction around 2015, if my memory serves me well, the oil price came tumbling down from more than $100 per barrel down to even 27 by the end of the year. So that affected the profitability and operating situation of the organization to a point where that oil price couldn't just sustain the operations properly, and they couldn't raise money. That's why they looked up to the PIC for a guarantee of 100 million so that they can raise money to drill the additional well. And that approval was done by the investment committee of the PIC. Mr. Chikudo was never involved in the transaction itself. He was just roped in to give advice on what could be done. What Mr. Madavo and the others did with that information, I'm not sure, but one thing I know is that he was part of the due diligence team that went to Houston in preparation for the approval of the guarantee. Mr. Ndaza, well, I don't have any comments because all what he said would have been taken to investment committee, and the investment committee would approve the investment on the basis that they are comfortable with the risks that he's raising.
Mr. Chikudu says that he advised the PIC not to go ahead with the provision of the guarantee and to exit the equity investment at the time, and that is your expert person in your team giving that advice. How was that discussed?
I can't recall how it was discussed, but...
Was it discussed at all?
Most probably would have been discussed, but one thing I know is that the investment committee took a decision based on the information that came from everyone within the organization that was tasked with the proposal.
Thank you. Yep. I don't know if you've got other questions. No? Okay. Dr. Matjila, throughout your testimony, and I respect the view you've taken about working with your team and listening to your team. And you've emphasized the critical role of the various teams, that you depend on their advice and don't make decisions on your own, that you're building a team effort. But witnesses coming before this before the commission have testified the opposite. And in fact, I'm not going to go through all of them, but creating or raising the question of a climate of fear, the question that when Dr. Matjila says it must be done, you have refuted that in your discussions. But I want to just give you a couple of statements and get your comments on that from people who are clearly within the team that you respect. Mr. Motherbatsi stated that in the case of IO, the document submitted for consideration to PMC2 was a scoping report and not a deep dive report. He stated that the key weakness in this process is that investment professionals who manage the portfolio on a daily basis are not empowered with a final decision on whether to take investment opportunities to the PMC or not. In other words, executives have the final right to instruct that the investment opportunity must be presented to the PMC. Executives don't change the document, but create pressure as going to PMC assumes that they want the investment to be approved. He proposed that there should be a formal recording if any analysts do not think that the investment proposal should be approved, and the team view should be highlighted as distinct from the executive view where there is a difference of opinion. As CIO and CEO, did you listen to or engage the teams given the above reference to pressure and a way of addressing it?
Commissioner, I was surprised with some of the comments that were made to this commission. I was really surprised because people like Mr. Mulebatsi I work closely with, and we've interacted on an ongoing basis. How they turn around to say what they said, it was a shock to me. And it's still a shock up to now.
So
because what they said,
surprise to you?
what they said, as far as I'm concerned, is not true. It's not true. I've not put any pressure on anybody whatsoever. I've allowed teams to do their work freely. I've allowed them to voice their consent. I've given them freedom to do what they like, within parameters, of course. Because if you give too much freedom, you end up with people like Magula doing what he was doing.
Sure.
So you have to be also firm in ensuring that the operation runs smoothly and it achieves what it's supposed to achieve. And so I was totally shocked, I must be honest with the commission, that some people said things, and as I said, I mean, some of them confided to me that they were put under pressure, enormous pressure. And I wasn't surprised when they testified in the manner that they did, that they were protecting themselves more than anything else, rather than telling the honest truth about how the PIC worked. It was almost like people prepared somewhere singing the same tune about how bad I was, which I don't agree with.
I accept that you don't have to agree with them, but it is what they've presented to the committee. I want to go to Mr. Varghese. In his evidence before the commission, he stated, I went, and I'm quoting, I went to Malabatsi's office and expressed my disappointment and frustration with the CEO's actions, that he had signed a subscription form ahead of PMC approval, and Malabatsi shared my sentiment. This was the first time I had ever seen anything like this in my career at the PIC. In para 16.6, he states that, quote, the CEO should have done the honorable thing to declare to the PMC that the subscription document and the payment memo were signed ahead of the approval process, and the business of the day was ratification thereof. We've had a lot of discussion about that precise point, but this is coming from one of your senior people expressing concerns about your non-disclosure, material non-disclosure. What would your take on that be?
I don't agree with Mr. Varghese. He says a lay priest. He said he was a lay priest.
Oh, okay.
Yes. I don't know if lay priests are allowed to tell lies, so God help him.
We're not going to go into what preachers
we'll
do
pray for him.
do
We'll pray for him. We'll pray for him.
Okay. Mr. Chikudu, which quoted above, in his statement reflects that no heed was paid to his expert views. You've spent a lot of time on how you listen to the advice of your experts, and that this, in essence, has cost the PIC or the GEPF at least $370 million US.
As I said, I mean, Mr. Chikudu, I'm not sure if he was allowed to write a report for the investment committee, because if that report didn't find its way into the investment committee, then it's unfortunate, because we would have probably included his comment. And if the PIC took a decision that it did, was because they thought the risk would be manageable. There are instances where the team will raise issues, would raise risks, but the transaction be approved because of comfort that the risk can generate returns. But it's not always the case, by the way. there are instances, Iron Energy will be a good example that a big risk has not paid off. And because the key variable, which is the oil price, simply tanked at the wrong time.
Mr. Chikuda said that he gave the report to Mr. Modavo, Mr. Dolamo, and Ms. Solomons. Would all three of those people simply have sat on a report that advises get out of this investment now? You're going to lose more money. Don't go ahead with the provision of a guarantee. Surely, obviously Mr. Modavo is very senior, but surely that comes to the attention of somebody in the decision making that we have this position taken by one of our experts in the field? You were not aware of that at all?
Maybe if they could be asked, maybe they have a better explanation than I can explain.
I've just got a couple of other questions. Do you think that and we've gone through the DOAs in quite a lot of detail, and obviously you've indicated that your preference is not just to use the DOA as it is as indicated, but to build the team and take team decisions. But do you think that the blanket authorizations provided to the CEO in practice, because in practice you have huge discretion or authorizations, remove the substance of board, IC, and PMC governance?
No, I don't agree with that.
I'm not stating something, I'm asking a question to say, given that authorizations, given the delegation of authority, given the roles that they play, do you think that authorization needs to be reviewed?
It could be reviewed if the board has discomforts. At the end of the day, it's the board that delegates. They're the one who decides what powers they could delegate and what is the extent and the effectiveness of that delegation and the risk involved in that. They're the ones who must decide on that. If they have delegated too much, they can always review and ensure that they rein in certain aspects of their delegation to take better control. But as it stands, with the understanding that there is an asset management business to be run, which on a daily basis means that interaction with the JSC and many other players, that if that is recognized, we ensure that no unnecessary red tape is created to the disadvantage of the PIC, because the more red tape you create in a competitive environment of listed investment, the more the PIC will be buying high and selling low, because they will be behind the curve all the time. So delegation, the board must decide what they want to delegate and what not to delegate, depending on their assessment of risk.
And obviously as a CEO, and if they were your CIO, you would also be members of the board, yes, and would influence that. Yes. So that you've got the balance right.
Again, Commissioner, if it comes to a point where the board says management must not be members of the investment committee, then it gives the investment committee with non-executive directors more, autonomy, if I were to put it, more space to deliberate without influence from the executives, the better. And if it improves on the investment decision process, that can be adopted, because at the end of the day, transactions that get submitted to these committees are a recommendation of management, which involves the executives, of course. So you may argue that they may be conflicted somehow, because then they sit in that committee and deliberate and take a decision. So that's an area that could be looked at.
I would certainly think it needs to, because you can't have a board that has oversight responsibility of their own decisions. So I think there's certainly a lot of area for that. One of the issues that have come through repeatedly is the question of fees earned, and related party transactions. This is a repeated issue in many of the transactions. The question for me would be, have you considered in your time as CIO and CEO the whole question of dealing with, and you did indicate just now that you did not have related party transaction policy. Do you have a fees policy? Is there a fees policy about who earns what fees for what in a transaction? I mean, the question that we've had here on a number of things has been, you know, fees paid to a person who comes and brings the deal, gets the deal done, and then gets fees for finding it. There's been a lot of that kind of issue coming up.
I think, Commissioner, the issue of fees has been on the table for a long time, and for some reason, it has just been avoided. You know, we've placed it many times to say, can we discuss this issue of fees? Because fees are actually a problem. Because bad behavior and bad transaction are probably a result of fees, because someone wants to make a quick buck or a quick fee, and they walk away. They don't have anything to lose. They just facilitate the transaction or whatever function they do, and they walk away. The PIC and the promoter and whoever sits with the transaction, you know. So we have, on a number of occasions, attempted to get the board around the table to discuss the issue of fees. And when I left, that discussion had not taken place properly. There has been several occasions. I think that needs to be looked at deeper, because we probably here at the commission as well, because of fees, evidence that have been uncovered here around who got paid, what sort of fees and so on. You know, it's been problematic, and it must be looked at very quickly.
In that regard, you've indicated that fees and that have not been something that you've paid attention to. If it's been that problematic as CEO, why didn't you pay attention to it? And when you took the matter to the board, is it a written proposal that was tabled?
It was not a written proposal yet. We were starting discussions around how we should handle fees and what sort of policy should we start thinking about in order to deal with the issue of fees. I've not been directly involved with fees, because those are part of the transactions, and once that is approved, there's a team, administration, and so on that deal with the payment of fees. You know, that is the extent which I'm involved will be at approval of the transaction level, quite honestly. So this issue of fees, we have tried to put it in front of the board to start open up discussions so that we can solve it, because it was in the media at some stage, you know.
And the question that I would also ask is, in terms of the IMA, the PIC warrants that all dealings on behalf of the GEPF will be conducted on an arm's length basis in the open market. Has this in fact been the case?
Can I get an explanation of that? Yeah.
Well, the IMA that you have says the PIC warrants that all dealings on behalf of the GEPF will be conducted on an arm's length basis in the open market. Are you comfortable that that has been the practice of the PIC?
I think by and large that would have been the practice, especially in the listed space where there is an exchange where deals can be done at arm's length. But of course, in unlisted space, you pick up one or two issues around related party transactions and so on and so forth.
Just a final question from me in terms of IO transaction. I mean, that transaction has taken so much ink, you know, we've spoken so much about it and all that. According to you, I mean, what could have gone wrong there? What went wrong? Or alternatively, what could have been done right? On a broad basis, what has gone wrong there?
I think, Commissioner, the idea was a good one. I think I still support it. I think the problem was in the execution. You know, how it was put together, and of course, JSC process was followed, we believe, the way it's supposed to have been followed. And when on the other side, you work with people who are driving a certain outcome without you knowing on the side, because you're only working with a document, it's quite difficult until someone tells you, or someone comes to this commission and raise all kinds of issues that if we had known, this transaction would have been handled differently. You know, so unfortunately, that's the challenge here has been governance around this transaction to a point of execution that has failed, in my view.
And what could have been, say, the failures from the PIC side of it? Because you are mentioning governance and the PLSs, and, you know, but what could have been, you know, from the PIC side?
I guess, I mean, it's again the issue of time pressure that was critical, that has put up in a situation, you know, but I don't think we would have discovered many other things that were said in this commission if someone didn't tell us and let us. I mean, despite the short time that was there, if someone doesn't blow the whistle to say, there is this happening, this is being adjusted this way and so on to make the transaction work, and you don't know, and you get approval of the pre-listing statement, there's not much you can do. You know, so it's really about the nature of the counterpart you work with and how honest they are. You can do a transaction in the shortest space of time if you work with the right quality document that is done honestly and accurately. You can do a big transaction in no time. But if people are allowed to cook the books and get them signed off by reputable institutions that are supposed to give you comfort that everything is okay, you can take a decision based on that, then you have a problem. There's not much you can do. Even if we had to do it in 6 months or 12 months, if that information doesn't come out. Because I don't think you have a way of saying, I'm going to get special treatment and demand information differently from what the other investors would be exposed to, then becomes unfair, you know. So yeah, I think the issue of the quality of information and the very importance of PLS that is supposed to have the right disclosures as explained by the JSC, accurate information approved by a reputable institution to give comfort to investors that they can use that information to make investment decisions. There seems to have been a problem in putting that information together, insofar as I is concerned.
Yeah. Could you say then one big lesson would be what, to make sure that you really interrogate the PLS, or you still say that the PLS is fine? And
the PLS, the concept is supposed to be fine. It's designed to give you quality information to make investment decision on, approved by the regulator and approved by regulator-approved institution to give you comfort. That's what it's supposed to do. Now, if it's not doing that because of various reasons that we're giving here, then you have a problem. It doesn't matter how long you can take in your due diligence, because there is this paper only that you're using to interrogate your numbers. That's, yeah.
To ask this question again differently, let's assume this transaction was done around June or August or whatever. There was enough time and you could hold PMCs. This was in December time and all that. Do you think the same problems that we are seeing now could have happened? Or maybe they could have been
and someone is
detected?
And someone is honest in the process to say to us, guys, I'm working on a PLS, but I'm told to adjust this and that to make the price this way and that way. That would have changed our view on the transaction. But whether it's 6 months or 12 months and that information is not revealed, then you're still going to work on the same information, come to the same conclusion because you think it's the quality information that you are using.
So you are saying that there was no way, no amount of due diligence could have picked up the problem. Is that what I'm hearing?
I don't think so. I don't believe so.
You still think?
Unless we say this would have been approached differently, similar to an unlisted investment, we disregard the PLS and demand to do it like an unlisted investment, which will be different approach altogether. I don't think then it becomes an IPO approach as the JSE would allow it under those circumstances.
All right, thanks.
We're hopefully going to get on to your recommendations just now, but can I just ask what I consider to be just simple questions? Firstly, on Sagarmatha, the PIC rejected their, call it an application for you to invest, but it still went to the JSE where the listing was rejected. Do you know anything about whether other investors, they got other investors to take the PIC's part?
My understanding is that once the JSE rejected it, it was over. It couldn't be done.
I would have thought that they wouldn't proceed to the JSE when the PIC had rejected their proposal.
Yes, because if the JSE rejects, then there's no listing, in other words.
So that I know. I'm trying to find how they got there, because the PIC rejected their proposal to invest. I would have thought that the matter would end there until they get other investors, even to go to the JSE. Or am I wrong?
I think the JSE did not approve the listing, but the process leading up to the listing would have happened anyway, of trying to get investors to subscribe, hence PIC was doing its own work with the view of investing eventually, which investing will be in the form of signing that irrevocable subscription. That didn't happen. And then the JSE also terminated the listing.
Okay, I think I understand from that answer. On to another.
Sorry, can I just follow up on that? Sorry, just on that, given that, as we said earlier, just to reiterate, can we get some record of the rejection of investing in Sagarmatha, please? Whichever the record is, to have told Sekondjala that there would be no investment in Sagarmatha, whether it's an email or whatever it is, about that decision and who took that or who did the communication around it, so that we can just clarify the sequence of timing there. Okay. Thank you.
All right, the next question. There's a lot about the leakage of confidential information. What do you regard as confidential information of the PIC that was leaked, or other confidential information?
So confidential information would be on the transaction side. Most of the information is confidential because it will involve financials of a company, the IP and all that issue that is contained in the investment proposal, including numbers and so on. So if it lands in wrong hands, they can know what the competition is up to and how they are positioned and so on and so forth. So the transaction side, there is that sensitive information that PIC has to secure as it deals with the different companies and counterparties. And then on the PIC side, things like minutes of meetings which must be confidential, you know, because they may contain similar investment information and other people's information on top of that, you know. So decisions on the board of the board that are supposed to be confidential and so on and so forth. So that's the nature on the corporate side. Sensitive information about decisions of the board and deliberations, etc. And then on the investment side, critical information that belongs to companies, including IP and so on.
Follow up there. Some witnesses have come and said, you know, the follow up is on whistleblowing. Some witnesses have come and said, you know, they wanted to whistleblow, but you know, if you whistleblow and they got problems with the CEO or the CFO or the top three, and they got a divided board, you know, where they couldn't whistleblow. How would one whistleblow in that kind of a, you know, setup situation? Because it's a difficult one. The whistleblowing in the PIC goes to the internal audit, and then it goes to the CEO or the audit committee, I think. But how would one whistleblow properly, given that?
I think the policy is clear that if I'm affected, I don't have to see the reports. I can't see the reports. They must go straight to the chairman of ARC or the chairman of the PIC. Or the CEO is affected, it can go straight to the chairman or the chairman of the ARC. So I think the whistleblowing process within the PIC is secure enough. It's very secure, but if people have malicious intentions because they want to use the media for their own purposes, in this instance, that's what's the goal. You know, they would go straight to the media and claim that the board is divided, etc., etc. You know, but the board was not made aware of any such.
Yeah. But if they don't believe in the board, like they don't trust it too. You know, they think the board is factional and all that. How would they, you know, try to escalate their issues? They don't say trust the management internally. They're not sure about the board. How can they whistleblow?
Well, I'm still not sure, because all I can remember is one individual that claimed that the board was controlled by the CEO, and therefore they decided to go straight to the police or work with the police. You know, but I'm not sure about the rest of the staff, because the whistleblowing, I mean, Mr. Sibia did use the whistleblowing process, and his case was investigated by internal audit and concluded. You know, so I don't have an answer. Well, some went to the public protector, of course, you know, but I still believe that the whistleblowing platform at the PIC is robust enough to deal with matters, and I wouldn't interfere. And there was a stage where I asked for the reports from internal audit. I think someone made a statement that I demanded the reports. I demanded those reports because I was concerned that perhaps staff is whistleblowing and their issues are not being attended to. You know, various things that they are raising. I was hoping to find a report that says so and so. So that's why I needed those reports. But all I got, I think it's in the document, you will see that it's other things. The only issue that PIC linked would be Mr. Sibia's case.
We are also required to make recommendations with regard to well, if we find that there is no, I can't get the term now, or there is no security so that confidential information doesn't go out. Now, obviously, confidential information did go out, which means something needs to be done. Have you got any idea what needs to be done in order to make sure that it's secure?
Commissioner, before I left, I had tasked as per board the decision or mandate to find the ways of securing the PIC environment. I was tasked with that. And I approached BCX, who worked very hard to first test our systems of security, of securing information, and recommend on the way forward. And they were working full steam to provide a solution, a comprehensive solution when I left. For the first time, our documents were now labeled strictly confidential where it's appropriate. So just labeling of document, because if my memory served me well, the first MST case, when I asked my colleagues to go and, first James Nogu case, when I asked my colleagues to go and open a case, they went there with an MST memo that had no security or classification at all. You know, and the police were unhappy. They said, well, this is not confidential, so we can't open a case, you know. Very simple things like that have been put in place. Encryption of information, many other things that were happening when I left, including security awareness. We ran a full steam PIC-wide security training, IT security training, technology-based, which compelled every PIC user of a computer to go through the training, or else they are not allowed access to use PIC computers. And that was done successfully. You know, so it was awareness and many other things, and putting the right infrastructure to secure the business. I don't know how far it is gone, but there was a comprehensive plan around it. Maybe the commissioners can find out how far they've gone with that project.
Okay. Yeah, I in particular needed some assistance in that regard. Lastly, your final separation with the PIC, was it all because of the James Nogu revelations or alleged revelations, or was there something else? What is it really that divided the board? Some wanting you to go, some not. What was it? If you are able to give me some indication.
Commissioner, I can't really get a handle on it, but I can only speculate that the manner in which we were running a tight ship within the PIC might have angered some people, you know, including the transaction processing and the plans around how we want to take the PIC to the next stage. After being so successful, I don't think it was necessarily supported by many or by some. And so a hostile environment had to be created, starting with a mere allegation about MST and the fact that I gave alleged girlfriend 21 million, which wasn't true, but that was sustained in a big way by the media, you know, to make sure that it's there and it doesn't go away. The board, after clearing me, there were some who raised issues, and out of that, the board was undermined, as I said, after taking that decision. And this thing was thrown back into another domain. And that sustenance, you know, you can imagine what it does to me as a person and my family. You know, I even lost my mother, by the way, because she was not well, and in the midst of all of these things, allegations around the girlfriend, something that is very foreign to her, to hear about me, you know, didn't take well in May last year, in May 2018. And so, this onslaught continued, you know, and some directors that I've worked with, non-executive directors that have assisted and guided in us driving the PIC to where it is, were always supportive. And they've been honest with me. Where I'm wrong, they would tell me that I'm wrong and guide on how I should move on things and continually recalibrate our processes to their satisfaction. Our transaction became a good one in this strategy of engineering my downfall. From MST, when MST didn't work, they tried many other things. All sorts of allegations by the whistleblower that we spoke about, from Litho and so on and so forth, making all kinds of spurious allegations. All of them supported or sustained by the media to make sure that they are there for a long, long time, wearing me out in the process. And also those who support me in the board probably felt too exposed. At the point where in July, the board lost Ms. Fubu and Dr. Manning, it became very clear that I'm facing serious headwinds, you know. So that grouping now, obviously their percentages increase on the board, and therefore they stand in a much stronger position to do what they have to do. And then we had the chairman just that came in 3 or 4 months later without any induction. He gets into the thick of things and he doesn't agree with the board's decision and so on and so forth. And that became clear to me that I don't have support of the chairman. I'm going to have even a steeper mountain to climb. But I tried to hold on, and most importantly, working with the team that I've worked with for years, you know, continuously appraising them on what's happening to the PIC, the allegations, all the investigations that were now being done by the minister, the previous minister, Gigaba, demanding all kinds of information around the PIC, all of those adding to pressure, a series of transactions that didn't make sense, and many other politically connected people that came and unfortunately their deals couldn't pass the test. At times I even think that maybe this IO transaction upset a lot of people that believe they probably had better transactions than the IO. But we had a different view because IO is long-term versus some of the short-term deals that we're looking at, including just exchange of BEE shares to another BEE that's not creating any value in sectors that are dying, you know. So I got into a point where I realized that probably IO was just one opportunity for a push to my downfall, engineering of this downfall, you know. I sometimes used to sit and think that, you know, a cat with 9 lives, I must be on the edge. So there was a stage when I felt that I think I'm now done. There's no life left. And I had to take a conscious decision. Of course, my family has always said to me, you've done your bit. Within 3 years in the PIC as a head, you've achieved so much, just let go. I said, but this is an unfinished story, I can still do it, unaware that things will start that are going to be bad. And me appearing in this commission was to say, I've built a career in 15 years, I think I've done well, only to be destroyed by a handful of people who come and tell the commission how bad the PIC have performed and so on and so forth, telling what I believe was not true at all. You know, projecting the PIC as this terrible organization that doesn't care for its people. Suspensions around IO. You know, very smart people that we've employed from the private sector that have driven the PIC to success, to be suspended on the basis of a draft report that is handed to the board in an afternoon and deliberated that evening, and people get suspended like that, and their suspension made public. That hurt me a lot, because these are people that I've worked with. People of knowledgeable people, qualified, great people that have built the organization into what it is. But Commissioner, I think there were people who didn't want me. They have the means and the resources and probably the strategy to deal with me. And the headwinds were just heavy, and I decided maybe it's time to shift. And in my shifting, in line with my employment contract that says you must give notice, negotiate with the board, the exit and so on, I performed all of that. But they took it as an opportunity to kick me out. They said, no, this is a letter of resignation, and therefore you must go the next day. I had indicated that I'll participate. I want to participate in this commission because I'm sure I can help the commission in one or two things, you know. They refused to pay me. I have outstanding LTI and LTI that they've promised to pay 3 years and so on. That have not been paid. I've been funding the dozen appearances that I've made to this commission out of my pocket, because I felt strongly that I need to go and present myself before the commission. You know, so it's unfortunate that I was told after 15 years at the PIC, late in the evening, must have been around 6:30 after, that I'm no longer wanted, and I had to leave the same day. I've never set foot at the PIC until the 23rd of November. But I'm happy I've been with my family. They see me more. Life is better.
Yes, thank you. Before I give my colleague an opportunity, I just want to say I'm really sorry about the loss of your mother at this time, or when all this was happening. I'm sorry to hear that.
Just a follow-up question in terms of the media leaks, and we saw the drips and drabs of transactions coming through. With hindsight, and I know, it's a PR issue, and the media, once they got something, they're gonna keep at it. Did you guys think about doing a big press conference and address all the transactions, all the big issues in a very long, big press conference and all that, so that at least all the transactions could be addressed in one day, one sitting?
Commissioner, the PIC is in a difficult spot, because you have Fires Act that says you mustn't just, you need to seek permission when you talk about other people's affairs and so on, And we were happy to publish records of unlisted investments. In a controlled, obviously we can't show everything, but we were happy. And so we were happy if Parliament asked us to do that. But the problem is that we needed clearance from the clients as well as our counterparties to say they are happy that we can do those transactions, because we had not done so in the past. Now, I guess in the future, whoever transacts with the PIC, if that's what the PIC is going to adopt, will be a clear policy that will be known to the counterpart that if you transact with the PIC, you must know that we are going to hang your linen out there in the public. Because we need to be transparent in many ways, so my view is that will help once PIC adopts that kind of approach to say, when you transact with us, know upfront as part of the relationship that some portion of your information will be made public. I'm sure it will also improve on the quality of transactions as well, because chance takers wouldn't want to venture into PIC and get exposed in that way, So I think going forward, transparency will be much easier if it's known up front that when you transact. But working backwards historically, you have to make sure that you don't upset, or you don't breach agreements that you have with some of your counterparties in the transaction, including, of course, the regulator and the client itself, because these are not our assets. The client must give us permission. It's even better if the client publishes the information, or they can still instruct the PIC to publish the information, but it's their information and not the PIC's.
So there were some constraints actually to calling a press conference because of those kind of issues, yeah.
Yes.
But in the past, in the future, I guess, if this happens again, then the PIC will be in a better position to call in the media and say, this is the situation, this is what's happening.
Even, agreeing up front once they conclude the transaction with various parties that now let's announce, we've now concluded the transaction, media come, let's tell you what it's about, how it's going to change the world, etc. How it's driving inclusive growth and so on and so forth. So that the media or the public is informed around the activities of the PIC in a lot more transparent manner.
Okay, all right, thank you, thanks.
My colleague is... Can we have a short break just before we get on to the recommendations? How long? 10 minutes.
involves CEO approval, is that correct?
That's correct, Commissioner.
Now, there's been some discussion about whether ratification by the PMC is possible, and I just want to refer you in that regard to the minutes of the IC meeting on the 30th of May 2018, which is Annexure DD 70.
Seven zero,
Mr. Commissioner. It is, it's the 5th page in on DD 70. Begins at the 5th page in on DD 70.
I've got it.
5th page in. It's headed Extract from the Minutes of the Investment Committee meeting held on 30 May 2018. Thank you, Mr. Commissioner. Now, Dr. Matjila, this is an extract from the minutes of the Investment Committee meeting held on 30 May 2018, is that correct?
That's correct.
Deals with listed, this section deals with listed investments, and it deals with the participation in the AO Technology Solutions private placement.
That's correct.
Is that correct?
That's correct.
Paragraph 7.1.1 says the committee discussed the internal audit report on AO Technology Solutions, AO private placement distributed at the meeting before considering the report submitted by the listed investments team. Is that correct?
Yes, correct.
Then I just want to refer you to paragraph 7.1.9, which is the second last paragraph, that document.
I'm there.
7.1.9. What it states is the committee noted that the transaction was done in terms of section 6A 6.2 of the DOA. You agree with that?
I agree.
That the DOA allows for ratification retrospectively and acknowledged that approval of the transaction was within the PMC lease delegated authority. Is that correct?
That's correct.
So this is the investment committee, which is a subcommittee of the board, confirming that that particular section that you did the AO transaction in terms of allows for retrospective ratification and approval is within the PMC's authority. Is that
That's
correct? And then subsequently, ultimately, if we go on to 2 pages on to the extract from the minutes of the investment committee meeting held on the 8th of August 2018. Are you there, Doctor?
I'm
Also deals with AO Technology Solutions private placement, is that correct?
That's correct.
And 11.12.4 says the PIC should always endeavour to approve transactions at a committee and avoid ratification of transactions. Is that correct?
That's correct.
IC had no difficulty with the fact that this particular transaction, being AO, could be ratified retrospectively by the PMC.
That's correct.
And perhaps just to gild the point, the retrospective ratification of transactions is not a reserved board matter in terms of the delegation of authority. Is that correct?
That's correct.
One can have a look at Annexure DD 14, pages 279 to 280, and it's not listed there. Is that correct?
That's correct.
just repeat the reference, DD 14.
DD 14, pages 279 to 280.
As a delegation of authority.
Is it 1.4, 1.4, DD 14?
1.4.
279 to 280, ne? Okay.
Yes, at paginated pages 279 to 280 of the annexure bundle. The point is that those are matters that are reserved for the board alone in terms of the delegation of authority. The retrospective ratification of investments is not one of those.
That's correct.
Then, Doctor, I just want to refer you to your statement, paragraph 475, on page 167.
I'm there.
Are you there?
Yes, of course.
You say there that the purpose of the PMC meeting, that's referring to the meeting of the 20th of December 2017, and the resolution was in truth to ratify the AO transaction, which it was known had already been concluded by my and Mr. Molabatse's signatures of the private placement subscription form on 14 December 27. Is that correct?
That's correct.
Then what I'm going to do is I'm going to refer you to Annexure DD 70. Again, this time to the first page of that annexure. DD 70. The first page, the extract from the minutes of the Investment Committee meeting held on 8 May 2018. Are you there, Doctor?
I am.
Okay. This is a report on AO Technology Solutions Limited. Is that correct?
That's correct.
It states that in paragraph 6.1 that the committee received a submission from the listed investments deal team providing background on the process followed during the approval of an investment of 4.3 billion in AO Technology Solutions Limited, AO. Is that
That's
correct?
correct.
Paragraph 6.2.4 reads as follows: approval and ratification of PIC's participation in the private placement were obtained at a special portfolio management committee listed investments PMC Lee meeting held on 20 December 2017, after which funds were dispersed on the 22nd December 2018. Approval of the transaction. Sorry, you agree with that?
I agree.
And the approval, as paragraph 6.2.5 says, approval of the transaction was obtained in line with the delegated authority of the PMC listed investments. Is that
That's
correct?
correct.
Now, we know that the resolution at the meeting of the PMC on the 20th of September 2017 says that the conclusion of the transaction was approved, not ratified. Is that correct?
That's correct, yeah.
But it was always
Sorry, you mean December?
December.
I apologize. But it was always the intention to seek ratification. Is that correct?
That's correct.
And you've been, of course, asked why then that wasn't raised, and you've given an explanation in regard thereto, but I want to refer you to Ms. Mora's statement that she was the chairperson of the meeting. Is that correct?
That's correct.
And if you can have, well, I'll read out paragraph 6.8.17 of her statement. 6.8.17 of her statement. Following my signing of the disbursement memo and in an attempt to follow up on the conditions I made when appending my signature thereon, I contacted the executive head risk, Mr. Paul Magula, to establish risk's position on the AO transaction. Mr. Magula alerted me that the requisite 75% voting threshold for the round robin resolution was not achieved, in brackets, i.e. there was no PMC approval of the AO transaction. I then contacted the GM Finance, Mr. Brian Mavuka, informing him not to do anything further in relation to the processing of the disbursement memo until the transaction is duly approved. I further contacted Dr. Matjila, informing him of the instruction that I had given to the finance team, and in the circumstances this transaction can only be implemented if due process is followed, i.e. PMC approval is obtained. Now, you testified that Ms. More had contacted you to arrange the meeting, the PMC meeting of the 20th of December 2017 to regularize the transaction.
That's correct.
Is there any doubt in your mind that Ms. More did not know that the transaction had already been concluded?
I have no doubt, Commissioner.
Now, then I want to, so we've then discussed the fact that the resolution contains the word approval instead of ratify, and it incorrectly captures the intention of that meeting. The IC gets told on the 8th of May 2018 that it was the intention, in fact, to note and ratify the transaction. Is that correct?
That's correct.
And then what I want to refer you to is the memo dated the 10th of May 2018. We have discussed this, Commissioners, and you asked for a copy of that, which I beg leave to hand up. I've marked it as DD 70.1, which follows in the chronological order between DD 69 and DD 71.
That's great.
Have you got it?
Yeah, I think I'm fine.
Have you got it?
I've seen it.
I just want you. This is a memorandum by the Portfolio Management Committee Listed Investments.
That's correct.
That's the same body who took this decision previously in terms of on the 20th of December 2017 to approve
That's correct.
the transaction. In the block headed Opportunity Overview, it says PIC Internal Audit highlighted the semantic mistake made in requesting approval from Portfolio Management Listed PMC to participate in AO Technology Solution Limited's AO private share placement. The intention was in fact to request notification and ratification of the transaction from the PMC.
That's correct.
And the purpose of this submission is to request notification and ratification from the PMC for participating in AO's private share placement ahead of its listing on the JSE in order to regularize the approval request submitted on 20 December 2017.
That's correct.
Is that correct?
That's correct.
And then subsequently, the PMC in fact notes and ratifies the AO transaction. Is that correct?
That's correct.
Now, just going back to one further aspect, you had said to Mr. Malabatsi as well at the time that you co-signed the subscription form that the transaction would be ratified.
That's correct.
And that the Commissioner asked you if that proposal emanated from you, and you confirmed that was so.
That's correct, yes.
So you were always looking for ratification.
Yes, but you see, this is where one wonders why it was never brought up. If you always had in mind that this will be a ratification meeting, and people in that meeting speak of approval or think that this is for approval of the transaction. And that's why I ask you the question, why didn't you correct that?
If I can refer the Commission to, and the witness to paragraph 485 of his witness statement, he does cover this issue. So it says, speaking for myself at the time, I did not see the practical difference between an approval of the transaction post its conclusion and a ratification of the transaction post its conclusion. To me, they meant the same thing. So I think...
So far as IPOs are concerned.
Yes. So if I understand you, Dr. Matjila, correctly, you're saying that practically they were the same thing.
They have the same effect, because in an IPO you would have signed off the subscription, before the deadline, as is expected.
They have a theoretical difference, of course. The one occurs before the conclusion of the transaction, i.e. an approval. The other one occurs after the conclusion of the transaction, but the practical effect is that they both, if one wants to use a neutral word, consent to the conclusion of the transaction.
That's my understanding, Commissioner.
Thank you. I don't have any further questions.
Thank you. We can then carry on. Okay.
What you've placed for us would take us back to the discussions we've been having all day. So I think it's for noting. Otherwise, we're going to reopen the whole discussion.
Okay.
Thank you, Commissioner. Yes, the intention was simply to refer you to useful passages in the documentation that you could consider in deciding this question.
But according to this memo, the person who came with the semantic mistake is the internal audit.
Yes.
Yes. He raised that issue.
Dr. Matjila, would you turn to the section then dealing with recommendations?
Thanks, Commissioner. I will be very quick, because I think we've covered most of the things throughout the 11 or 12 appearances that I've made to this commission. Very briefly.
Ours are more.
Sorry, Commissioner?
Our sittings here are much more than 12 days.
But I guess I've broken the record in terms of witnesses.
But you also broke the record in terms of your statement. So your statement determined how long you were going to sit in that chair.
It reflects 15 years and 2 trillion.
And a few billion.
Well, that will be sorted out, I'm sure, with new arrangement and structures and so on. And a good outperformance. Commissioner, I think all I'm saying here is that I have a lot of experience. I've been exposed to this organization for a long, long time. If we go straight to 630, I'll just jump certain paragraphs where I believe there is some substance. I believe what will make the PIC a better organization post the commission is a good vision, mission, values supported by an appropriate legal and regulatory environment. Operating model that has relevance to client mandates, appropriate human capital management strategies and good leadership, fit for purpose investment government policies and processes, and most importantly, adequate IT platform. I think if we can go straight to the legal environment, I'll just want to touch on that briefly. I still believe...
Can I just, the one question on the vision, the question is this. If you look at 633, Are you saying that the PIC needs to lead in terms of the Sustainable Development Goals, the SDGs?
This is actually what has won PIC awards internationally as an asset manager.
Yes.
We're driving environmental, social, and governance issues within our investment process.
Yeah.
And that won us awards. And then from there, we then lifted the strategy to cover sustainable development goals. In other words, building a portfolio that is designed to drive sustainable development goals within the mandate parameters of the clients.
Yes, more akin to this company called Robeco, I think.
Robeco is one such offerings in the global space to allow us to have that technology that we can apply even in the South African environment as well. I think they've done exceptionally well in that area. So that partnership was designed to give PIC that capability.
All right. Okay, thank you.
So 634, I'm saying the PIC should be championing the president's effort to raise 1.4 trillion rand. This is now the 100 billion rand, $100 million, I think $100 billion that the president is raising. Because PIC is the biggest investor, I think we should at least be part of it. And most importantly, ensure that it's led by South Africans. We all know that the corporate South Africa is sitting on piles of cash. If you mix that with the PIC, at least you have most of the funds that are required to drive this from South Africa. Otherwise, if you allow that to be foreign only, it will have unintended consequences of selling the country unawares. So we have to be careful how we raise that money. Legal environment, I think the commissioner will agree with me that the SAP has been independent. It withstood all kinds of criticism and it has been standing and operated quite well. I think PIC must consider that kind of model to make sure that it is politicized in managing the funds of other government-related entities. The role of the regulator becomes very important here.
Just a question there, yeah. So I'll keep stopping you there and there, you know, I've got quite a number of questions there. Just in terms of 636, SARB, you know, the SARB is you know, how it operates, it's, you know, it's within the constitution of the country. You know, how would you make the PIC sort of an independent body, given that that is not, you know, in the constitution?
Well,
SARB is, you know, its independence is in the constitution itself. The ex-governor is here, so I'm sure she knows that.
I thought the PIC Act will help insulate the PIC as well.
Sorry?
If it's not the constitution, it could be the Act itself, the PIC Act, ensuring that it. In fact, I was looking more at the SAP Act, you know, that regulates the Act as to how it operates. That maybe PIC should adopt the same kind of approach.
It's quite, because in Norway, apparently, well, there's the fund there, you know, the oil fund, whatever.
Norges Bank.
Yes, it's actually run within the central bank there. Is that what you're saying?
That's more or less the thinking. It may not be necessarily within the bank itself, because those are oil proceeds from the oil that are invested in different, and it will be performing the same kind of asset management. But that reserves are for the country. Here we are talking about pension funds mainly of others. So the mandates may be different because they are controlled by the clients on the other end. So I thought if the legal environment allows it to play almost like the SAB in managing
the SAB Act. So look at that and see whether the PIC Act could be tweaked around. Is that what you're saying?
Okay. And also it brings the issue of governance. I think the commissioner keeps asking whether PIC has an advisory board or a management board. I think that should be thought through as well, because I thought the advisory board will be suitable. That can be appointed by a politician just to deal with it. But once you get into the operations, you need a strong investment committee across different, you know, asset classes. that has, we'll talk about the structure. I think the PIC will have to be broken into distinct businesses that do not overlap and have each with their own governance structure, with holding company managed by this board of advisory board of directors.
We shall come there because...
And then the FSCA will take the responsibility of appointing or approving the investment committee, because if you break it into listed investments, unlisted investment is in ISIBA and unlisted property, that way you can have IC as the key investment committee that deals with the affairs of that. And the regulator must then approve the membership of IC so that they are fit and proper and independent and so on.
Yeah. Not the board, just the sort of the parts
the board
of the
can
IC.
the board can recommend,
Yeah.
but the board will recommend to the FSCA to approve any such appointment. Because then the regulator will help in terms of clearing many other issues and ability to make investment decisions as well.
And to approve them, do you think they must write the exams?
I think they should.
RE exams, the
they should write exams, because I mean, if the PIC really wants to compete like a coronation, let's say the listed component of it, you compare it with coronation, then you have to have the right governance that drives performance, which means that the investment committee will have key individual representatives mixed with people from outside with requisite knowledge to enhance the decision-making process. So the IC will have to be constituted to make sure that those who serve in IC, their interests are aligned with the client in a way. And also it's very important that the client's regulatory issues as well are taken into account, most especially that they are government entities, most of them. So their mandates, will discuss their mandate. Their mandate must also talk to broader economic imperatives that the PIC must drive as part of the mandate.
An issue here that we did speak about it. The pension funds, when you look at the JSC is made up of big companies, Naspers, BAT, Glencore and all that. I mean, those companies don't make money here, and the bulk of our pension funds are stuck there, How can we find a way to invest money in our local economy? Because, I mean, buying shares on Naspers and BAT doesn't help our country.
I think the easiest will first be a definition of a benchmark. You may have a benchmark that is locally biased, and you can mix that with a benchmark that has others, in other words, global exposures, as you have outlined. And then the regulation must come in to say, how much do you expose to the local benchmark, and how much can you put in this non-domestic exposure, including your foreign allocation, perhaps, as part of your foreign allocation, and at the same time then increase the weighting of unlisted investments in the regulation 28 to ensure that unlisted investments are able to drive economic growth, as you well know. Then in that way you will have. Our attempt with things like IO, if I may just tell you the IP, what I was thinking here, was that we should be setting up IO type investments on the JSC covering different sectors. You're raising money to drive manufacturing, infrastructure, agriculture, in the listed space, because some of them are not represented there. But you can still use the listed JSC to put together those solutions for other investors for that matter. If IO was done correctly, I think it would attract other investors, crowding other investors into driving technology. If you put together an IO in agriculture, underpinned by the PIC, you do it well, you attract others and you drive agriculture in that way. Manufacturing, the same story and so on. So JSE could be a very good platform actually to create opportunity for those assets that are not necessarily represented, but that are important for economic growth.
So meaning that you are saying then the JSE can break up the all share basically into a local benchmark and a global benchmark.
That's what I think. And the regulators can say now, this is how much you should be allocating to the local economy to drive local economic growth.
Yeah.
And similar to that, the biggest investor like the PIC can be proactive in creating assets that are not listed on the JSE, but that are important for economic growth by listing things like IO in the agricultural space, IO in the manufacturing space, and so on and so forth. In that way, you then crowd in other investors to drive sectors that are not represented on the JSE, and then in no time you'll get a complete representation of the economy on the JSE, hopefully.
Yes, because I've been thinking that does it make sense just to keep putting money in BAT and I'm not saying these are bad companies, I'm just saying, as a country, does it make sense for us to keep just parking the money there,
There has been, Commissioner, there has been instances, if you look at how the oil share has performed relative to the economy. You see a huge dislocation. At some stage, the oil share was hitting new highs, and it was NASPERS and others, whilst the economy was not growing. That shows the serious dislocation. Now, if pools of capitals are sitting in the JSE and the JSE oil share is the benchmark, then you have a problem because that money doesn't find its way into the economy. Creating this benchmark of local companies and PIC being at the forefront of creating more opportunities to grow this, because you need a reasonable benchmark with critical mass for others to assist to invest in such. In that way, that concerted effort can really grow the economy a lot quicker.
Okay, thank you.
I think we've touched on MOIs. That's something that can be sorted out very, very easily by the new board. Operating model, again, I've advocated that the PIC...
Can I, just a question, just in terms of the CIO and the COO, given that the structure that we are talking about will have sort of mini CIOs or so, do you think you need a general CIO, sort of a super CIO?
Yeah, because if you say the PIC at the top, the holding company that will hold this, will probably have listed investment within the holding company itself. So that's where you'll get group CIO, group CEO, group CFO, because at that level, strategy need to be formulated at the top and passed on to these subsidiaries for unlisted and listed and unlisted property to implement.
All right, get it.
So the operating model will have to be along those lines, and that each one of the subsidiaries will have its own investment committee. But the top being the one responsible for risk management at global level. Not that there's no risk management happening at the subsidiary level, but consolidating everything at the top and driving the investment strategy there.
Then, just in terms of the subsidiaries, are you saying they're going to have their own boards, or it will be just internal boards, where the main people on the main boards serve on the subsidiary boards? Or you think there must be normal boards from the outside and all that?
I know companies like to control, and they will say, but then the chairperson of subsidiaries will have to be appointed from the main board to create an appropriate control.
Yeah.
But you then need the right experts to sit, you know, not necessarily sitting on the boards, because then you go back to the same problem, you know, of what the PIC fund itself trying to do everything under one roof and creating potential for breach of the law, such as competition, because you have listed investment, unlisted investment. You know, at times you look at the same sector, competing companies, one unlisted, one listed, and that can create serious problems for the PIC going forward.
But then how would they report to the main board then if some of the people at the main board are not on the subsidiary boards? How would the main board know what the other companies are doing at the lower level, the subsidiaries?
The risk management and the operations will have people that go and collect information all the time. There has to be that. And I mean, I'm sure Liberty Holdings, for example, which will have subsidiaries like RMB and the properties and others, you know, will have some kind of reporting lines to the main board, because that's where things get consolidated. But what is important is this Chinese walls that are created so that there's no movement of information laterally, but it's just across, and not much can be done because the top is not necessarily making decisions, you know, on behalf of the subsidiaries. And I mentioned 644 Liberty Holding could be looked at. You know, Sanlam, I think, has got the same characteristics, can be looked at. And if you talk about state-owned entities without saying they are doing well or not doing well, you know, you have, I think it's a Central Energy Fund, which has got a Central Strategic Fuel Fund and others. So in the public domain, there is that kind of structure. You know, it can just be improved, you know, made sure that it works, you know, so, yeah. Client mandates?
Just another one. Okay, so you are mentioning that there should be 4 units, isn't it? Four big companies there.
I actually see 3. So it will be the group with listed investments and strategy setting and so on and so forth, research, development.
Yes.
And then you will have underneath unlisted investments, that's Isibaya in particular, and then unlisted properties.
Okay, all right. And then where would I think it's external managers, where would they sit? Do you want to mix them with the Mulebati's team and all that? Because Mulebati is competing with them. And
I think I think in practice they are normally separate. So you can create a third one. You're right. Of
funds of funds, multi-manager.
Yeah, I think all mutual is like that and other. They've got their own funds of funds. Sanlam as well. So
multi-manager. So would you would you have the private equity funds of funds in the same pot with the multi-managers, the externally managed funds?
I would,
because those are 2 different skill sets. I mean,
yeah, I think really it's all about how you want to use multi-management. Sometimes multi-management, if you do it well, it could actually be a feeder to listed. If you don't have this notion that people are going to steal IP from external managers and use it for their own.
I'm sure they will.
But if it helps the portfolio and they're comfortable, I don't see any reason why. It's value add to the bigger portfolio, you know. So I'm in favor of, say, private equity fund of funds sitting with the private equity team. Absolutely. And defining the private equity team mandate as not necessarily direct investment as we do it. I would probably want to set up a fund of funds for co-investing. So in other words, running a passive strategy in an unlisted environment and allowing the satellites to be the ones doing active investment, so direct investment. And if they need a big check, they go to the PIC
I see.
you know,
I see.
for core investments.
Yeah.
As opposed to PIC doing a 4 billion rand
Yeah.
private equity transaction.
Yeah. Okay.
You know, with the setup. Unless the setup changes completely, but you need lots of people.
Yeah.
And Mr. Sithole did raise an issue that if he's going to pay more, he will, for fees, he will be very reluctant to, you know, to do so. But at the same time, if you pay more fees, but you get outperformance that covers those costs, then it's a win-win situation.
Yeah, then meaning that we're talking about 4 now, because you say we need to have a separate multi-manager there.
Yes, you
For
can
external,
have
from external.
Yeah, exactly.
Yeah.
So they can handle both listed and unlisted, because these are just external managers that you allocate money to. I don't see chance of information, you know, filtering between listed and unlisted in the manner that it can.
Oh, I see, yes.
If we are all sitting in one room. So sensitive information must be safeguarded, that there is no insider trading at all in the PIC activities.
All right. Okay, so to come again, so give me those 3 or 4 units again. Let's
That we agreed that funds of funds, both listed and unlisted, is one piece.
Yeah.
And unlisted investment is in Isibaya, and then you have unlisted properties. Then at the top, at the holding company, you have listed investment together with others, risk, portfolio management and valuation, and so on and so forth.
Yeah.
That will be performing certain functions on behalf of the board to aggregate the information that's coming from the subsidiaries.
All right. Yeah.
Client mandate as well will have to be crafted to be relevant, and you have raised the issue of JSC, that if the monies are not used to grow the economy, the assets are not going to grow. That has to be recognized, that it would be nice to see the JSC running when you are not stimulating the economy. The problems are bigger now, as we can see them. So funds must be used to grow the economy, and the mandates must be crafted to take care of that.
Yes, I think it was Mr. Stoller who said, or somebody, that the biggest risk actually is to keep investing in the JSE, not in our economy.
Yeah.
Because, you know, soon the job problems will continue. So that is a big risk for...
That's the big risk.
To have low economic growth, isn't it?
That's correct.
Yeah. Okay.
And we talk about that 647, you have UIF and CC. Again, this mandate should be biased towards job creation and sustaining jobs for unemployment insurance fund and CC. More so now that the structure of the fund is 5 times fully funded in an economy that's shedding jobs. So that could be a very important tool to deal with the current situation if allocation is made to job creation and job-saving initiatives.
Another question, in terms of Mr. Stolle, he said that if you have a new model, the operating model, and you ask to increase fees, you know, as you said, like it's just not gonna do it willy-nilly. You got to demonstrate some, you know, some value there. How would you attack that?
Looking at the PIC as it is now, and the surpluses that we've seen throughout the years, this model could be implemented over time and not even affect the fees. Because of the surplus, because PIC's cost-to-income ratio should not necessarily be the same as the cost-to-income ratio of a coronation, because the structure is different. Unless PIC charges performance-based fees and all those kind of things, then you can change the model slightly. Then you can change the model slightly to preserve the cost-to-income ratio, because you'll be making money on outperformance. But if not, then it means the cost-to-income ratio must be different, probably closer to 75% or so, versus 55% target in other places, you know. So that needs to be considered a different model where the surplus is as small as possible to ensure that operations can function sufficiently. But if there's a change to what performance-based fees, then a different model can be put in place with different cost-to-income ratios. So there is still room. Human resources, of course, you need the best of the best and pay them properly. And don't suspend them on standard operating procedures, because you're not going to get any of them to come to the PIC.
And do you think, say, paying them the 75th percentile works? Does it work? I mean,
you pay them the 76th percentile, and you can pay them 50th percentile, as long as you know that you dangle the carrot of outperformance. You say, if you outperform benchmarks in this way,
yes,
this is how much you can participate.
Yes, yes.
You know, and they will be happy to drive performance in that way, because once you pay them a huge basic fee and very little performance-based fee, then they can only be lazy, because their package is guaranteed whether they perform or don't perform.
Yes.
They still get their guaranteed package anyway. So in an asset management, you want to drive performance and therefore pay reasonable on the basic,
okay,
but have incentives to drive performance.
All right, good.
And of course, everyone must be approved, the right management with the right skills and knowledge. Investment governance, I think we grappled with politically exposed persons as the biggest risk. That need to be sorted out, you know. Deal origination, I think there was a lot of talk.
Can we just dwell a bit on the PEPs, because it's a headache, it's a major headache across the world, you know, this issue of PEPs and all that. How do you think the PIC has got enough policy or action around that, and is there something that needs to be done there? Because PEPs are a huge problem. I mean, you can't deny them the opportunities, but you need to find a way, because they are a huge problem. You know?
I assume that there should be a combination of law and transparency that kicks in.
Yeah.
You know, whoever is a PEP wants to do, then they know that they have to be happy to be scrutinized and be made known that they are being funded by the PIC.
Being funded, and it's in the open, and
it's in the open and so on and so forth. You know.
Yeah. Just in terms of transparency and stakeholder management, many people have been saying the PIC is not transparent, is not talking to stakeholders. Do you think that, you know, some have said the CEO needs to do quarterly meetings or annual results, they must do like what normal companies do, you know, like the IDC or Standard Bank, and have an annual jamboree or whatever to talk to stakeholders, or they must have, you know, big meetings once a year, once in 6 months, you know. What do you think of stakeholder management? Town halls, you know, some people have say even the CEO of the PIC should have an annual town hall where everybody who's got questions, they can come and ask. The investment strategy for the year, what do you plan to achieve, so that people can bring proper transactions, because people don't know what the PIC does. You know?
I think that can be done. It's something that the PIC should consider, but we've always worked on the basis that our biggest stakeholder here are the clients, and adequate reporting to the clients and interaction. And most importantly, we report on PIC operations activity. We are owned by government, so Minister has to present our annual report to Parliament, and we go there and tell the nation how we've done on operations. But deeper details around investments, because we are using other people's money, we thought that could be handled by the clients themselves. But if there is some kind of a relationship, a much better relationship between PIC clients as the biggest shareholder, a stakeholder, on how they are going to deal with the broader stakeholders, the public. I think we were working on that at some stage with the GPF, and it was coming, well, I think it has to be resuscitated so that we are not seen, to be making GPF's money PIC's money, or the PIC is not seen to be making GPF's money their money. They should be talking about PIC operational matters and the GPF talking about their assets. So there is that needs to be considered as well, and that can be debated between the PIC and agreed and the GPF and the other clients and agreed on what sort of messaging or communication do we have with stakeholders.
Coming again there, do you think it might help the PIC to say on an annual basis that, look, this is our strategy, this is the sectors we're looking for, this is the kind of deals, and then you know that for that year people know that they cannot bring these transactions, these are the key ones, and you can get the best transactions.
I think we had already started with that. We ran a big tender process inviting, especially I think it was private equity managers, different sectors and so on, and the next step was to say these are the sectors, exactly what you say, that was planned at that time. But we also need to be careful that we don't end up creating, what you call a put option for other people, for other investors, that that, no matter what, the PIC will, underwrite whatever.
Big money is coming into this sector.
You are not going to lose money as long as you use the PIC to, that must be taken into consideration as well.
All right.
658, I talk about fees. This so-called transaction fees, especially facilitation, need to be looked at so they become transparent and clear. Other models internationally, on the inclusive growth side, I like the SNIT of Ghana as an example from Africa, how SNIT has built Ghana. The pension fund in Ghana.
Can you explain further there, please? Yeah.
The social security, it has invested a lot in development of Ghana. I'm sure every little building, road and rail, etc., would have been funded by SNIT successfully, and I assume that they would have made returns. So PIC may not be different. It can play that role, provided that there is an appropriate governance. In fact, I was going to make a suggestion that why should PIC invest in government guaranteed bonds of state-owned entities, especially those that are supposed to drive certain aspect of economy, whether it's ESCOM, whatever, Transnet, etc., because on behalf of its clients, which are government departments, there's an implicit guarantee, so you can forego that and release that contingent liability that is sitting in the books of the nation. So that's something that needs to be considered, that when the PIC invests in state-owned entities bond, they may not come with a guarantee. And there could be an adjustment for risk, as we did with all the bonds that are not government guaranteed that PIC had invested in ESCOM. There is a spread to recognize that. But the effect of it is that it's releasing that contingent liabilities on the books in Treasury, and therefore giving it space to do other things. And we can even stretch to say, if governance is designed properly, why can't PIC be seen as alongside government and own portions of state-owned entities? So it's not privatization, but it's the people of South Africa owning a piece of state-owned entities to deal with the current problem, as long as governance issues are resolved properly, and PIC is a participant in driving this, Because it's nice to say I'm in a bond, it's safer, it gives me interest every month, but you have a downgrade that affect the whole bond portfolio. When yields kick up by 1% and you are sitting on a 580 billion portfolio, the losses are huge. And if it's one entity where you can say, well, I'm prepared to do it differently to ensure that it doesn't affect the sovereign credit rating, so that a bigger portfolio is saved in that way, and the country is saved in that way, you know. And I don't have to forgo 10% as a what you call civil servant just to make up for the shortfall, but I can deal with the problem immediately, which is ESCOM.
So are you saying that the PIC could look at purchasing some power stations, say by Kusilo or Midupi, and say this is a check, you know, from the PIC, and then ESCOM can use the check to retire debt? Is that what you're saying?
If they were to restructure ESCOM and say, here's a good ESCOM, here's a bad ESCOM, investors come and invest in the good ESCOM, because you will be seeing the return, and therefore you can even convert your debt into equity in this better, cleaner ESCOM and so on. Then you can deal, the process that you get, you can deal with this other problem, you know.
Okay, yeah, okay. Some ideas there.
These are just ideas that we throw around, but hopefully they help the nation.
And this Ghana fund, this 659, you are saying they've done roads, rail, but they do put money on the Ghana, the exchange, the stock exchange.
They are a player in the exchange, just like the PIC.
But did they spread it?
I don't know what is the size of their exposure. PIC is almost 10% of the JSE.
Yeah.
I don't know how much they have, but they've been...
Both on the...
Ghana has been built around SNIL.
Okay, thank you.
Yes. I think we've covered most of the issues. I mean, what is next is just my comments, final comments on how I feel about this whole thing, Commissioner. It will be very quick, if I can read it into the record now. In conclusion, I wish to state with humility that I'm extremely proud of the legacy I'm leaving behind at the PIC, as well as the PIC's achievements. The growth rate of 308 billion in 2003 to well over 2 trillion in 15 years later was spectacular. I'm proud that the fund's assets have resulted in a more prosperous, stable, and dignified retirement for nearly 1.5 million South African workers. I'm proud that I've played a role in transforming the skills base at the PIC and in our partners in the asset management industry to be more representatives of the demographics of the country, of this country. Especially with the opportunities opening for black women, I'm proud also that new funding opportunities were made available to diverse group of black entrepreneurs through the Isibaya Fund, when all they received from commercial banks was rejection. And proud that during this time, the PIC advanced loans to several hundred SMMEs and tens and thousands of students. I'm chuffed that we have supported emergence of black asset managers, black stockbroking firms, black advisory firms, and successful black entrepreneurs. I'm extremely proud that, sorry, Commissioner. I'm extremely proud that all this was achieved under the most trying of market and political circumstances. I wish my successor entitled all the wisdom, forbearance, and luck in achieving the vision, and I pray that the spirit of James Nugu has been cleansed from the corridors of the PIC forever. Commissioners, it's been a long and daunting testimony on my part. It has, it can be imagined, taken its toll on me and my loved ones. I've been subjected to most painful but maybe necessary scrutiny, but undeserved unfair smear campaign and a devastating character assassination by those who should know better, and quite frankly, by many who knew very little about who I am. This is the reason I wish to thank you, commissioners, for providing me with an opportunity to tell my side of the story as detailed as I did, present to South Africa the sterling work done by committed professionals who take honor and pride in their work tell a story of betrayal by some whose objectives were clearly dissimilar to mine. Lay bare mistakes, missteps, and shortcomings experienced by the PIC as a changing and transforming organization. And importantly, to ensure that South Africans in general, and pensioners in particular, that their hard-earned income is safe and growing, and that the highlights of missteps that the Commission has highlighted are an exception rather than a norm. As I've said from the beginning when I introduced the subject of my exit from PIC, I wanted to assist this Commission to uncover as much facts and truth about the happenings at the PIC in the 15 years which I served. I hope I fulfill this task, and now as I move on with my life, I pray that one day the efforts me and my team made would have contributed in whatever small way in assisting this country to achieve its objective of inclusive economy, of bringing a sense of pride, in particular to many black professionals who stand no chance in a surprisingly hostile economic environment. And in the end, the preservation, protection, and growth of our pensioners' monies. And hopefully that those who would come after us will not betray this objective. And if I may, Commissioners, I also think it is important that the Commission dispels the perception, which may or may not be correct, that the targets of investigation by this Commission exclusively look at black entities, black-owned entities. It has occurred to me that all transactions that came under serious scrutiny are those that one way or the other involve black participants. It may just be my perception, but very difficult to dismiss in view of the fact that we dealt with many, mainly white-owned companies. Finally, I thank the media for the intensity of its focus on our work, not because we were powerful, but we were charged with the important task of being trustees of other hard-earned money, and fervently believe that reporting has not been done with a jaundiced attitude of a Fanonian observation that when a black person enters, reason escapes. Finally, thanks to my legal team for the efforts they put in this response and believing in my story when all others possible, out of ignorance, malice, and perhaps those who draw inspiration from the cruel theology which know no forgiveness, no compassion, no humility, to which the quality of mercy is foreign, and so they declared, "He's down, finish him, and he's down, and crucify him, crucify him." I sincerely hope that the Commission will not join this chorus to finish and to crucify me. I'm certain and I will rise again and still make a contribution to a better South African Africa. Thank you very much, and best of luck with the rest of the work.
Thanks, Dr. Matjila. Like it's been a very long journey. When I saw your statement, it's like a book, like 229 pages. So I was like saying, sure, it's a long read. But I must say, from my side, I actually found the first part quite informative, actually, because I knew the PIC, but I didn't know the sort of internal workings. So, your full statement was quite interesting for me. And I know we have to look at transactions and victimization, but I really think it taught me a lot, So thank you very much for coming here to the Commission. Thank you.
We might have rushed into those, but I need to ask both council whether they have any further questions to you.
Mr. Commissioner, it had been arranged with my learned friend that there are questions on Pareto. I don't know whether the Commission intends to deal with that.
It is mentioned Pareto is mentioned in the statement. but we have actually had virtually conclusion addresses, and one wonders now how we deal with that transaction.
Mr. Commissioner, we're quite happy to then not deal with it at this stage. It is part of the investigation. It is part of the deals we've been looking at.
Can I suggest that you list the questions that you want to ask and give them to Dr. Matjila's counsel and to Dr. Matjila, and then we can have his responses on affidavit. Would that suit you, Mr. Rulofse?
Mr. Commissioner, that would suit us. There is a very full and detailed statement by Mr. Kakana, which I believe has been made available to yourselves, and which I am instructed accords with Dr. Matjila's view of what happened in respect of that particular transaction. And I think that at this point in time, that matter should lie where it is with respect. I certainly don't have any further questions for Dr. Matjila. I think that he has answered and said enough in the time that he has been here with respect.
Did I understand you correctly that it's okay for the questions to be listed and sent to you?
Indeed, Mr.
Yes.
Commissioner, we don't have any difficulty with that.
Thank you. You said you're fine with that, Mr. Mahat.
Mr. Commissioner, we are quite happy with that suggestion that we put questions and which would then be answered under oath by way of affidavit.
Thank you. Nothing further from our side. Yes, since you have kept track of our proceedings, you know by now that at the end of a witness's testimony, I thank the witness, and I want to do the same with you. But with all the others, I said to them, you might be called back, and I hope it won't happen with you after the 12 days. But thank you very much for the time that you offered in order to place everything before us. You certainly cleared up certain things that might not have been clear, and so on, and we thank you for that. I don't know yet what our report will look like. I just hope that, and I think that there won't be any crucifixion of anyone. Our report will be in terms of the facts that are placed before us, and that is it. Our recommendations will follow those. So, fine, you asked us not to crucify you, but it will never be our intention to crucify you or anyone else for that matter. Okay. Thank you so much. Thanks. Mr. Rulofse and your team.
Thanks, Commissioner.
Yeah.
Thank you, Mr. Commissioner. Thank you for assisting us, and over the past days that Dr. Matjila has testified.
We'll then adjourn until tomorrow morning at 9:30.
Pardon me, Mr. Commissioner, can we revert back to the 10 o'clock arrangement as the witnesses we've got lined up tomorrow in our planning? I understand that we would start at 10.
That's fine. We'll then adjourn until 10 o'clock tomorrow morning.